Video on a You cannot mute
conduct annual general body meeting. Investigation Your Lordships. Serial number 77 in cause list number 1, Your Lordships.
You want to mention?
Please.
Yes.
Serial number 35.
Uh,
Kindly have made 2 weeks
after vacation.
please.
Yes, madam.
Your Lordship, serial number 77, it is a mining matter, Your Lordships, wherein a stoppage notice was issued to the petitioner. A similar matter was posted before your Lords on 11th and an order was passed partly allowing the matter. Due to oversight, it is between the same parties also, Your Lordships. Due to oversight, it was not listed on the same day. If it can be taken up second half or end of the list to pass similar orders, if possible, Your Lordships.
So that order in the other matter is available?
Is available, Your Lordships. I have it.
2:30 will take.
2:30.
My lords,
No urgency. It will be posted in regular course. When you file, remove office objection and
The office is, the office objection has been removed. Without the following the review procedure, the authority has given a permission to open the cow slaughter factory. There is a cow slaughter factory, cow slaughtering factory in Kalburgi district, where even objections has also been filed, not to give a permission, but without hearing the petitioner, the objection has been, permission has been granted.
no urgency.
list to serial number 2. The matter was listed on Monday.
Serial number?
List to serial number 2.
List 2 doesn't.
No, that matter was listed on
List
Monday.
1 mentioning in list 2.
List 1.
42.
My lords, may be permitted to mention the matter, my lords. That is
42, what do you want? Agenda, first week of February.
My lords, list 1, serial number 7, my lord.
February.
My lord.
February 11.
my lords, if I may be permitted to mention one matter, my lord.
61, yes. Oh.
My lords, list 1, serial number 84, my lords.
FIR was stayed, and despite that, charge sheet was filed. Therefore, we made the accused the party. So therefore, the office objection may be overruled. Because he's the investigating officer.
Office objection is overruled, subject to further order.
My lords, list 1, serial number 7, my lord.
Yes.
List 1, serial number 7, my lord.
They're not qualified to get get appointment.
Which
in the
matter?
Environmental committee.
Which matter? Serial number?
Not serial.
My lord,
Memo.
What is the urgency?
Lord, the respondent number 9, without qualification, they are holding post for Committee for Environment, my lord. The petitioner's qualification has not been considered.
No urgency, yes.
my lord.
To be listed once you remove.
List,
the
list number one, list one, serial number 7.
office.
List 1, serial number 7, my lord.
Serial number?
7, my lord.
Serial number?
7, 7. I pray for adjournment.
Madam, serial number? 37. Don't admit this with the online mentioning until the physical mention is over. 37, what do you want?
Serial number, my lord.
I pray for the translated copy.
So time. Whenever you want, take it, take.
My lord, serial number,
And serial number 7.
serial number 3, my lord.
I pray for
My lord.
short adjournment, my lord.
Which one?
Serial number 7, list 1, my lord.
Serial number?
7.
7.
7. I am for respondent.
Why
I
do
have
you
engaged with the senior counsel.
delay of 6 days?
Please, ma'am.
Why
I
do
appear
you-
for appellant
My
in
lord,
this.
my lord, the senior counsel is out of the town. So,
First week of February, 12th February. Yes.
List matter. Well, rather than single judge remanded the matter instead of my lord appreciating the prayer of the petitioner, because the petitioner or the 3 orders has been passed in the writ, but 3 different petitions. Petition my lord told company, my lord, the honorable labor court has been passed on a order, my lord, agency to pay the amount.
But no
My lord,
urgency.
any
Serial
date,
number.
my lord's convenient.
Date then.
List,
My lord, fresh matter, my lord, challenging the order. Now the orders has been posted before the, my lord, on Wednesday. Therefore, my lord, any date, my lord's.
20th January.
My lords, it may be permitted to make one mention, my lords.
Council on Tuesday. Tuesday. No. Since he is saying that. So 26th at 2:30. Twenty-six 11 at 2. Yes. Yes, Mr. Twenty-six. 26 we're telling.
Appellate are challenging the selection list of the, for the first of,
Lordship, may I please mention item 41, Lordship?
for the first of, library supervisor, I scored more marks than the candidate who selected, madam. But, the governor single judge has allowed the petition, but, dismissed the review petition, madam.
Let it be a call. Yes, any online mentioning? Yes.
Sir, any mention through VC, sir?
Lordship, may I please mention item 41, Lordship?
41, yes.
Lordship, this is a child custody dispute, Lordship, contempt for not letting me meet my children. Now, Lordship, a lot of water has flown under the bridge and we want to settle the matter, Lordship. I'm appearing for the husband, the
Custody matter,
petitioner.
custody matter.
Yes, the child custody, two children, 9 and 7 years of age.
Yes.
Despite apex court orders, family court order, no visitation was being given. But now the writ court.
Pending before Supreme Court, same matter.
No, that's not the case, Lordship. That's a different matter. In this particular case, Lordship, the connected writ court has given substantive orders of visitation, which is now being complied with. We only want to settle this case, Lordship, now. We would request the Lordship to refer this matter for mediation, Lordship.
Preparing for the respondent
When-
in that matter.
You want which date?
Lordship, we would request the matter to be referred to mediation for 19th of this month.
19
For mediation.
for mediation, but other side is it?
I am appearing for
Consent
the,
for mediation.
appearing for the accused madam. I'll seek instructions, madam.
He will seek instructions.
Then Lordship
When
will
will
have
seek
it for the 19th, Lordship, because
19.
19, please, madam.
19th of November, Lordship. I'm so
Yes.
grateful.
Like,
Yes,
My
anybody
lords,
else?
serial number 84, my lords. Serial number
Serial number?
84 appear on behalf of the appellant.
Serial
84,
number?
my lords.
84, yes.
84, my lords.
Yes,
Please, I appear on behalf of the appellant, my lords. I seek for a week's accommodation, my lords.
it will go in the last week of January now. 17th
Okay.
January, as requested,
Okay.
the learned advocate appearing on online, 17th January. As requested by learned advocate.
But serial number
Anybody
three,
else? Serial
serial
number?
number 3, my lord,
Yes,
the respondent issued the notice to appear to consider our application. Therefore, may kindly grant 2 weeks time, my lord.
why?
They have called upon to appear to produce the certain documents. Respondents. In view of the judgment of this honorable court, they have issued the notice to the parties to consider our prayer.
Let it be called out, Mr. Counsel. Yes. Post number 2. 23. CCC 132 of 24. Learned advocate Mr. Anandappa Balloli does not press the present petition, stating that the order under contempt is complied with. Dismissed as not surviving. It's a list. Mr. Advocate General, what is to be done about contempt?
We have filed our complaint report in all those matters, my lords.
All matter.
In all, for 41 matters, my lords. Only 42 matters, my lords. We have,
That matter was listed on Monday. Madam Shweta Krishna appeared. Date was fixed for 10th December for non-compliance.
so that may be deleted, my lord. This,
Which one serial number?
List to 2, serial number 2.
2 will be listed on 19th,
10th December, date is already fixed.
10th December. Like, list 2, serial number 2, that is 1107. 1107 will be listed on 10th December as requested.
the only other thing is, my lord, if the petitioners, we have filed a compliance affidavit. If the petitioners if a lordship call out, if they have any grievance of non-compliance, then only only then only those matters maybe have to be heard. If they are complied, matters can be closed then and there.
But they all are present or they are not present?
They must be. Or then you should have it 2:30.
2:30 will be.
2:30, then.
List one, so content matter, seal number 1. Shailesh, yes, Husur.
Apply not comprehensive, implement the single judge order. Again, they filed the writ appeal.
So you are Ravindra,
Please,
continued in service,
not
not continue. Notice returnable on 17th December.
Seal number 2. Allah Reddy.
Incorporate the party-wide public rules in the comprehensive development plan.
Notice written on 18th December.
Seal number B.S. Nagaraj. Seal number 3.
Single judge order, compare the order.
What is this about your sound purpose?
Page 17. Page 17.
Why you are seeking time? Why you are seeking time?
Notice that issued in respondent number 3, madam.
No,
14/11/2000.
So it is in the,
Documents as your,
what is the notice?
same documents as your, in 14/11, today is your,
So it is in the process of compliance. When you are going to appear?
not compared.
In the process of compliance.
I am for the complaint.
It is in the process of compliance. You don't understand. Notice is issued for the purpose of compliance. Notice to the respondents returnable on 4th December. To be listed at 2:30 in view of the fact that learned advocate of the petitioner produces copy of the notice issued by the authority. Dated 12/11/2024, which indicates that the directions of learned single judge in pipeline for compliance. Learned advocate Mr. Learned additional government advocate Mr. Harish shall take instructions about the time limit within which the
R1 to R4, madam, accused number 1 to 4.
compliance will be obtained.
This seal number
At 2:30.
Seal number 4. The Lakshmi Menon.
The dissemination material, the accused does not comply with the law, order of the lower court.
Yes. So what is the content? What is the content?
The content is that the judgment letter is supposed to pay the compensation for making defamation.
Not paid. That this publications are deleted?
Not yet.
Not deleted.
Not yet.
How do you say not deleted?
It's not, still not taken down from the social media, Your Lordship.
What was that publication?
Not encouraged. The complaining was the Karnataka State Cricket Association member, Your Lordship, Secretary, Your Lordship.
Notice returnable on 17th December.
Serial number 5.
Leases with blasting and non-blasting, my lord, if that distinction can be made, my lord, the problem will get resolved. So far as blasting cases are concerned, my lord, it can await the proper investigation, everything. (22) is also connected to the same thing. Yesterday also, your lordship said taking
My
it.
application was filed by you.
My lords, can I make one request in that application, my lords? Instead of 31st July 20, we have sought for modification of the order dated 31st July 2024, my lord.
Correct.
I would seek only slight modification in this, my lord. What has happened, your lordship? Let me give the facts, my lord. There are totally 52 leases in this area, my lord.
Government
Sorry, 50, 50, my lord. 50 leases. Out of which, my lord, 38 mining leases have expired. What is valid as on today is just 12 mining leases, my lords. This is within the 20 meters radius of KRS dam.
They are running.
Which are there? 12.
Running or not running?
They're not running by virtue of the court order. Out of which 12, my lords, 4 involve blasting. 4 out of 12, 4 are using blasting for the purpose of carrying on mining activity. And 8 are using. By virtue of the court order, this court order, both stopped by virtue of 8 January 2024 and 31st July 2024. This court, has passed an order on 31st July saying it is for the Dam Safety Committee to examine the case of the petitioner and take appropriate decisions strictly in accordance with law on merits to be placed on the records of this court. Serial number 6 in the order dated 31st July, the last paragraph. So, we are not agreed by that, Only can I request here, the Dam Safety Committee and the Mining Department, so that, let them. We are now only back to only 8 applications, Let this. I think there are 2 or 3 before your lordships. Petitions are pending before lordships. Let them file their application. Both the Dam Safety Committee and the Mining Department will take a decision within next 10 days or 15 days and place it before your lordships, so that I'll solve the problem.
It is very fair.
We'll leave it at that.
Then will you constitute a separate committee or?
No, same committee include the mining department so that there's no conflict of between the dam safety and the mining. They say we permit, we don't permit. Let them, as long as the dam safety is not affected, then we shouldn't have any problem insofar as these 8 are concerned, Insofar 4 is concerned, or future, in fact, we have to get a Indian Institute of Science. We have appointed them, They'll be giving us a report. As soon as that report, we'll place that also before your lordships.
What do you?
Lord, I bow down, my lord. My only difficulty is, my lord, I am not able to breathe now. So, my lord, they have been keeping this for so long, my lord. Let them, my lord, say in cases which involves no blasting, my lord. what more investigation they have to
So-
do.
It's a permanent solution, my lords. We don't, because ultimately we're concerned with dam safety, my lords, and the people and all. This order is passed on 30th July 2020, I mean, 1st of 7th January 2024, my lord. Another 1 month, nothing is going to happen. Maximum 1 month or any other time limit your lordships may decide, we'll do it at the earliest.
As the amicus, I had suggested to your lordships that the dam safety committee comprised experts look into it. Unfortunately, despite your lordship's directions, they issued an endorsement saying they don't have jurisdiction, which is a questionable position to take, my lords, basis the provisions of the act and also your lordship's direction. Now that my friend, the AG, is submitting that they will consider, I think that.
Because we don't want to take, ultimately dam safety is important, my lord. Let the committee tomorrow, they have shirked their responsibility to the mining department. Tomorrow, ultimately, we are concerned with dam safety.
Say that this aspect does not fall within the purview of the.
No, my lord, that is what I understood what my
That
learned
was the
friend-
endorsement issued to my learned friend, the petitioner's client, Mr. Naganand's client.
As per your lordship's direction, we
No.
went to them. They
No, my lord.
said that.
But in fact, we ought to have visualized the mining department was.
No, in fact, that is why I thought, my lords, instead of,
Well, very well. I cannot oppose that.
So what they shall examine only the aspect whether the activity carried out with this particular unit is for.
whether they can carry on the whether the mining activity they're going to carry on will affect the dam safety or not. That's all.
That is it.
That should be sufficient.
So far as non-blasting cases, my lord, the department, department have already approved my mining plan, which indicates I'm not blasting. So
After hearing,
Yes,
my
my
lord,
lords, we
they-
hear them also, my
they
lord. No
given-
problem.
no, my lord, they already have all the information.
No,
My
let
lord,
them hear, my lord. Let them produce a material. If your lordship may fix a date, let them give all place the material. The dam safety committee, the mining department and the petitioner, let them place. Or if any conditions has to be imposed, let them
we will nominate a person, office from the mining department,
my director of mining, my lords.
director mining.
Though, my lords, if I may very respectfully suggest, the decision be taken by the
Yes.
safety committee.
Correct.
Committee. But one of the member will be the director of mining.
That of,
Please, my lords.
please.
So
But they
tomorrow,
have-
the
they have
reason is,
said-
my lords, tomorrow, there should not be a difference in opinion between the dam safety committee and the mining. Because what the dam safety committee said, go to the mining department. That cannot be done, my lords, because ultimately they are answerable to the dam, my lords, the dam safety committee.
my lord, the dam safety committee has already taken a decision that they cannot decide this.
No,
They have now
your
filed an
lordship's order is
application.
there, we'll comply with it. We'll not go on technicality or direction by your lordships. We will go by your lordship's direction and implement it.
They shouldn't come back again and say we are not complying with the order.
Connected his prediction.
So one by one. So this decision will be taken in respect of the impleading applicant or all four?
Well, it will be, let it be on, generally with regard, as of now, the applicants who are before your lordships, my lords.
All non-blasting cases. I am up for the non-blasting.
Who are before your lordships, we'll let them appear. The lordship may fix a date for the petitioners who are before your lordship. Let them place the material as to how they.
That this procedure shall be followed in respect of all such cases if it is if application made to dam safety committee.
Please.
That would be.
Please not to come to.
Quite so,
Please,
my lords.
Lord,
In
fair,
fact,
please.
there was a floodgate of applications. Your lordships disposed all of those, directing them to go to the committees.
No, there are.
A general order of this sort.
Here we are fixing time.
There.
When you will appear?
I'll appear tomorrow, my lord. By tomorrow afternoon, I'll be before them. Today also I can go.
Monday you appear.
Please.
Monday is holiday, my lord.
Today will you permit, if you all permit us to pass order in chamber, we'll do that.
Please.
Please.
Monday being holiday, then Tuesday.
We'll share the first draft of the order to learned counsel, Mr. Sondi, who is amicus curiae. Any suggestions are there to make it technically
Please,
sound?
Lord,
That's all. Technically sound.
Lordships. So
Technically and factual.
So
Please, my lord.
By evening, I think I'll be able to dictate in the recess and
Please.
share copy with.
grateful.
Then Monday you appear and within.
No, Monday is a holiday.
Monday being
19th.
Tuesday.
Tuesday.
Or Saturday, I don't mind appearing.
Just, my lord, let them not push, my lords. Kindly give some reasonable period, my lords.
2
So,
weeks.
2 weeks, my lord. To make it 3 weeks,
My
my
lord,
lords.
all documents are already with them, my lord. There's nothing new I'm going to produce. Mining plan is approved by them. I have an
Okay, we
approved
are-
mining
Manoj,
plan signed
we
by
have one-
director.
On or before 30th.
Yes.
Please,
On or before 30th November, you take a decision
please.
and communicate to the applicant. What about the original petitioner? Same exercise?
Please.
Same exercise?
This connected petition, we won't use any plastic.
Yella case.
Same exercise.
Quite so.
So you appear on the, when will you appear? You will appear on 20th.
Tuesday.
Both will appear.
Let everybody appear on Tuesday, Manoj.
19.
Will pass you. So we are disposing of the main petition notes also.
Please, Manoj.
Lordships.
There's nothing remaining.
Lords, similar order in serial 22 also. Ma'am. Yesterday, your lordships had heard them both together.
22.
Serial number 22 today is the same issue. Ma'am. It's a different person, that's all. That's also
The
non-plastic.
main PIL, your lordships are keeping on the file.
Correct.
To be kept alive.
Please, my lords, because your lordships have
Yeah,
called
because-
for successive reports from the committee.
So this will be order in IA of
IA.
Naganand
IA
Please.
and 22, Manoj.
and interim order in the case of the main petition.
If my lords would like to dispose of serial number 22 finally, my lords, I leave it to your
We will
lordships.
dispose it.
But the main PIL would kindly have to be. So grateful.
22 and the IA, Manoj.
To give me at 1:30.
31 also same.
One by one. Otherwise, this order will not come.
31 also. 31 also.
And 5.1 and 22.
Why is 5.1, that's main PH.
No.
Can I request
That's
5,
right.
5.1, Manoj?
Obviously, the member will be from the mining department,
Yes, Manoj.
will be a member only for the purpose of considering this application.
Yes, Manoj.
Quite so.
That is what I'm,
Not to be, obviously, not to be the member of the.
Yes, my lord, because it's a statutory committee.
no, that's what I said, Manoj. There's a committee under the act, Manoj.
So your say is also accepted, our say is also accepted.
Your lordship says accepted, not my say.
So you are saying
Just
that
assisting my lords to resolve the problem, that's all, Manoj.
very fair of.
Manoj, can I request 5.1, 22 and my learning student 30, 31.
Your IA is number 8.
IA number.
IA
There's an
number
IA
8 is
for
my,
direction.
IA number 8 is my application.
IA 8 is yours. So your is to be allowed in that
Please, Manoj.
accordingly. So we'll deal with all IA.
IA number 8, 5.1, 22 and 31.
5.2
5.1.1,
and 30,
22
20.
and 31. Mr. Chidanand, matter.
22.
And 31.
31 also same.
Please, Manoj, my,
Same with pertaining to the license.
no, is it the same? I have not seen the, I'm going by what my learners.
32. 32.
See the file.
31, 4010. WP.
License has been cancelled.
No. Then-
Deemed the license.
No.
Fairness, my lords, my
No,
friend
no,
should
you
not
can't
bring in those aspects.
The license was cancelled and we filed. the
No.
connected-
We are confining today's order to IA8,
Where there is license.
then the page 5 and 5.1.
Government-
Those are judicial matters.
Rest
The
will be,
judicial
rest will be
matters
listed
cannot
on
be
28th,
delegated.
we'll examine on fact.
Please.
The 32 may be, 31 may be listed on 20th. So that we'll examine in light of.
Manoj, that, at least on facts, we should be clear, Manoj.
The same.
May I give your lordships the numbers of the IAs on which your lordships may make the order, my lord. Today, my lord, there is a WP 3339 of 24 is shown as kept below. That is a disposed of matter, my lord. In that, there is an IA number 4 of 24 filed by me.
Yes.
Then, my lord, in IA in WP 19835 of 23, there is IA number 7 filed by the petitioner seeking clarification.
It is also disposed of.
Yes, that is pending, my lord. Your lordships could make an order in that. And third, my lord, is WP 29420 of 24
29.
420 of 24, that can be finally disposed of. It's a serial number 22. My lord. The main prayer in this is that we must be given permission to mine because we are not blasting. So prayers in all these three, your lordships may kindly make a order.
Get appearance involvement, separate.
Please. In the light of this order, my lord, the IA filed by the state yesterday may not survive.
No, you should consider that and pass the order, man. Question of survey.
So all IA will be disposed of.
Disposed of.
Yes. What I mean, my lord, is that no
assume
further order is needed because your lordships are disposing of these matters in this manner.
if your lordship take my ear, rest of it can be disposed of as infructuous.
Allah, recalling. I'm only saying, my lord, recalling may not arise in first.
Does it make
It doesn't make any difference.
about your fees, then we'll do that.
No, my lord.
As an amicus, my lord.
Only thing, my
Next
lord,
order.
after some days when the matter comes up, the court will notice there is an IA for recalling. What happened to that?
It is, your IA is to be allowed accordingly. To that extent, then you're
Disposed
also
of
to be allowed.
accordingly, my lord, doesn't.
Please.
Both are allowed to that extent.
Please, my lord.
31.
Let it be dealt separately, my lord.
31 will do 20th.
Yes, your
20, 20.
I get the corrected contempt file. That will not survive your lordship.
On 20th we'll take.
Please.
20.
Grateful.
Right.
Beautiful.
Six and seven are urgent. So writ appeal matter, seal number 8 to Somchekar.
I appear for the appointment. Appear for the appointment.
Yes.
But I am aggrieved by this portion of the order at page 21, para 12, my lord. Page 21, para 12, my lord. After about 5-6 sentences, my lord. In the instant case, it starts, my lord. Lord, in the am I audible, my lord? My lord, in the instant case, in the absence of any material forthcoming to establish that the respondent is receiving rents from the apartments, whether it can be said that the respondent is gainfully employed, be denied 17B wages. Page 83 may kindly be seen, my lord. There is an order of this honorable court, Labour Court had granted My lord.
Yes.
My lord, that's what the learned single judge says, there is no absence of any material forthcoming. I just refer to my lord to page 83, my lord, where the learned single judge of the Honorable Court earlier, when the labor court granted 40% of the interim relief, has observed, my lord, at page, it starts at 83, but relevant pages 102 to 105, my lord. At 102 in the middle, my lord, it starts at 83, the judgment, at page 102, my lord. Seventeen B proviso, my lord. Proviso says, seventeen B proviso, my lord. Provided that where it is proved to the satisfaction of the High Court or Supreme Court that such one had been employed and had been receiving adequate remuneration during the such period.
So we are not with you, Mr. Counsel. Heard learned senior counsel, Mr. So and so, who appeared online to make submissions. Paragraph. The order sought to be assailed by filing this writ petition is dated 19/2/24, passed in IA number 1 of 23, in pending writ petition number 167/23. Where the state impugned order from alone a single judge has held that the respondent workman is entitled to receive the bail under section 17 capital B of the Industrial Disputes Act 1947. Full stop. The said paragraph. Interim application was filed by the workman seeking the benefit of section 17B of the Industrial Disputes Act 1947 and duplicate herein after equal to the act. An affidavit was filed stating that the workman was not gainfully employed. In the background, the petitioner management had sought approval of its action of terminating the services of the respondent workman by filing application under section 33 2B, 2 regular B small into bracket of the act, which application came to be rejected. Full stop. An award dated 24/3/23 was passed. This award came to be challenged by the petitioner company in the aforementioned writ petition number 167773 of 2023, in which the aforesaid interim application for benefit of 17 capital B was moved by the workman. Paragraph. The objection raised by the petitioner employer was that the workman had a source of earning and that he was receiving the rents every month. On the other end, it was the say of the workman that he was only a self-employed person, which was done for earning the bare livelihood. It was further contended that he was not employed in any establishment and was not receiving any regular income oblique regularization, but only gathering the livelihood by doing the self-employed activity. The provision of section 17 capital B of the Act reads as under, then quote 17B. Full stop. Where the employer has challenged the award passed in favor of the workman and the proceedings are pending, the workman is entitled to claim the benefit of 17B by getting paid the last drawn wages upon the conditions of said provision, upon the satisfaction of the conditions mentioned in the said provision. The bare reading of the section says that full wages last drawn by the workman, inclusive of any maintenance allowance admissible to him under any rule, will be payable during the pendency of the proceedings against the award, which may have been filed by the challenging the award, which may have been filed by the employer. Before the High Court or Supreme Court. It is stipulated that such benefit of full wages last drawn will be given to the workman who has not been employed in any establishment during such period, and an affidavit by workman has been made in that regard that he is not employed in any establishment. And in that regard, full stop. The proviso of the section paragraph would indicate that the court shall not order the payment of wages last drawn under the section if it is proved to the satisfaction of the court that workman had been employed and has been receiving adequate remuneration during any such period or part thereof. Full stop. The condition that the workman is not employed in any establishment, and further that is not establishment is satisfied. Full stop. The workman is also filed affidavit to that effect that he is employed in any establishment. The proviso would not operate in case of the workman, inasmuch as he is not receiving any remuneration. Full stop. Only stand which could be taken by the employer, that's the appellant herein, is that the workman was earning by self-employment. So in this regard, learned single judges would refer to the decision of the Supreme Court in Tribhuvan Das Haribhai Tamboli versus Gujarat Revenue Tribunal, AIR 1991 SC 1538 into bracket, in which the word employed was considered for its context and import. It was observed that the word employed inward comma, is to be read as employed in any establishment. Employed in any establishment is again in inverted comma. The self-employment paragraph would not amount to employment, since the workman workman has to survive, and for that he has to do some activity for earning the minimum livelihood. If self-employment is earning the livelihood, comma, he could not be brought out of the purview of the grant of benefit under section 17 capital B if the other attendant conditions are satisfied. Lone single judge has further relied on the decision of the division bench of this court in Delta Infralogistics Worldwide, Integrated Worldwide Limited, only Worldwide Limit, Worldwide Limited versus Sri Mohan K.E., which was writ petition number 1074 of 2021, decided on 2/9/2022, in which this court has held that the self-employment does not amount to an employment in any establishment by placing reliance the establishment, full stop. In so holding, comma, this court lays reliance on the decision of the apex court in Tribhuvan Das Supra. Similar view is taken by the Supreme Court in Rajinder Kumar Indra, KINDRA versus Delhi Administrative Secretary into bracket Labor and others into bracket 1984 bracket and 4 SCC 635 big bracket over full stop. For all the aforesaid reasons, comma, the order passed by one single judge entitling the respondent workman to the benefit of section 17B wages up to his attaining the age of retired superannuation. Don't write. By 17B wages, comma, could be said to be imminently proper and legal. No interference is called for in this writ appeal. The appeal is dismissed.
Still number 9. Okay, Sridhar.
Appeal for the appellant, my lord.
Yes.
Appellant was a practicing advocate of this Honorable Court. Later, she was appointed as a lecturer in Law College and retired as principal of Vipuram Law College. My lord, the government order was passed admitting the teaching staff to grant in aid. That is at page number 46, my lord. Government order dated 28/11/2012. Translated copy, my lord. Learned judge observed in my favor, but however rejected the petition. Therefore, I am before your lordship. Kindly see the page number 45, my lord. Government order. The government perused various representations submitted by the Unaided Private Law Colleges Association, taking into consideration of this and based on the report of Professor Mali Muddanna, admitting 24 law colleges for grant in aid, wide order dated 4/10/1999. The government reviewed this report and admits for grant in aid of 19 colleges which are in good condition and obtained affiliation to run 5 years LLB or third year LLB or both 5 or third year LLB course. The government is pleased to admit grant in aid for the following 19 private colleges. Serial number 5 is my college, my lord, Vipuram Law College. This with a certain condition to verify each institution whether they are eligible or not. After verifying, the impugned order has been passed at page number 67, my lord. English. My lord, this 26/8/2015, the impugned order, class 6 says, my lord, at page number 67. The grant in aid of the staff comes into effect from the date of this order. My lord, this order
Your
is,
date of, what is the date order?
and I retired in the year 2014. When
Date of the order, which is the date of the order?
this date of the order is 26/8/2015. Your lordship will find it at page number 64.
26.
Government order dated 26/8/2015. Clause 6 says at page number 67, this grant in aid of the staff comes into effect from the date of this order. But this could not have been done, making it as a prospective, because the original order is dated 28/11/2012.
That grant in aid benefit is given to you in first.
Given as per government order dated 28/11/2012. But it was not implemented because they have to verify the college, each college and everything. Later, they have passed a formal order. While passing a formal order, they postponed the date of coming into effect. They could not have done it, my lord. When a 2012 order was passed, government order, I was in service after serving 30 years. Unfortunately, I attained age of retirement in the year 2014. This order, after verifying each colleges, they have made individual orders. After verifying the staff strength, the student strength, they took time, my lord. That can't be a reason to deny the employee who was already in service 2012. That is the issue. Learned judge also holds that, yes, I am entitled, but he rejects. In the order of learned single judge also, page number 14. It is observation is in my favor. Para 6. Is clause 6 coming in my way to get a grant in aid benefit?
What do you say?
Lord, attained superannuation on 28/2/2014, my lord. The order had, government order is on 26th August 2015. Lordship may kindly see paragraph 10 of the operative portion of the judgment, my lord, at page 16, my lord. Insofar as pension and gratuity is concerned, my lord.
That we have seen.
Please, my lord, paragraph 10 and the direction 2, my lord. That is in consonance with annexure G, my lord. There have been this petition to be treated as a representation, my lord, for the purpose of pension and gratuity. That is in favor of the appellant. The second part of the relief, my lord, insofar as fixation of salary is concerned, my lord, that has been rejected. They want the refixation of the salary to be calculated, my lord, both for aided and non-aided service.
Why this? So as per 28/11/12, what is the date of effect?
2012, I am working
You're,
as a principal of the law college.
no, you are given benefit under 28/11/12.
2012, but that benefit while extending, they were used to, verify each colleges.
Tell the date. Tell the date that you are given benefit from which date? You wanted the benefit from
28/11/2012.
15.
No, 12.
12.
12.
That is not permissible. Because that you're on showing that at page 64 that this government order is dated 26th August 2015.
My lord, 15th, 2015 order is only a consequential order for 2012.
Page here. So you are not agreed by clause 3. Salary, special prayer for refixed salary by calculating the aided and non-aided.
My lord, my only humble submission, 28/11/2012 given benefit to the working in the law colleges. My lord, there were some certain condition in that order, my lord. Conditions are that each college have to be verified by the government, whether they are eligible for grant in aid code, whether teaching staff is there or student strength is there or not. While verifying that condition, they took time about nearly 3 years. While they admitted my college for grant in aid, but while making it, only persons who are working in 2015, they made it. The person working in 2012 has been excluded. That is the defect in the order of 2015. If that class 6 is not there, I would have got the benefit. Learner Single Judge also said that in para 6 of the judgment, page number 14, he gives a finding in my favor. Learner Judge gives a finding in my favor, but denies the relief. My lord, that clause 6 in the 2015 order has to be quashed and has to be leaved. Because my lord, 15th I was not in service, 2015, retired in 2014. How could they extend the benefit which was already given in 2012 to made it a prospective from 2015? Only few teachers working in that got the benefit. That's the only issue involved in this appeal, my lord. Learner Single Judge at page number 14, para 6, give a finding in my favor that I am entitled for the benefit of 2012 order. Para 6 and 7. If it is so, then 2015 order should have been interfered.
So you are not agreed by clause 3 of the impugned order, page 18.
Impugned order 2015.
Page 18, go to page.
Page 18.
Clause number 3, you are not agreed.
Class 3, my lord. No, I am agreed, but if 2012 order is given effect, I will get it.
Automatically will get.
It's a fallen. I will get.
Representation will be considered, my lord. Page 68, my lord, may kindly receive.
My lord, again representation.
Learned advocate Mr. So-and-so for the appellant and learned additional government Harish for the respondent to appear to assist the court in.
My lord, if your lordship is not agreeing with me, then my lord, permit me to hesitate matter before the government. My lord.
That is the order.
That is the order, my lord, page 68.
The order, but my lord,
if you succeed in representation, you will have this salary.
My lord, 6 years have left. I am 70 years. Again filed a writ petition, another 70 years, another 10 years will lapse. I will be nowhere to get relief. Though government order 2012 gave. For that reason, I filed this.
So they will take their own call. They might grant the benefit from 13 also, 14 also.
14. Up to 14 they have to give. That's my only argument.
So what do you?
That class 6 should go, my lord. As long as that class 6 stands, which
You
has
can-
not been quashed by this Honorable Court.
The best provide time limit to comply with. the-
Consideration.
Allah, they are considering the representation, but my lord, at that stage it is there. They will quote that one. Again, I have to challenge that government order 2015 because it gives a prospective effect. This Honorable Court at one time has to say whether that prospective effect is right or wrong. Even in the second round, if I come before this Honorable Court. That is the only issue your Lordship has to decide. That clause 6, making it prospective is wrong because I got a right,
Or learned advocate, Mr.
then I may permitted to make a appeal before the government.
It is already provided.
Yes, that there since
Learned
your Lordship is not
After
agreed.
making submissions for some time, learned advocate Mr. So and so for the appellant stated that learned single judge has directed to treat the petition as representation and has further directed the authorities to, competent authority to consider the petitioner supposed to be as claim by taking cognizance of notification dated 28/11/2012, comma, in particular, clause 12 thereof, and to pass approved orders. Post of it was submitted that in view of the above direction, comma, petitioner would pursue the representation. He requested that the court may direct the competent authority of the respondents to consider the representation and take a decision within a stipulated time. Full stop. The request is reasonable. Full stop. The directions of learned single judge in deciding the representation shall be acted upon by the competent authority of the respondent, and an appropriate decision in accordance with law shall be taken within 4 weeks from today. From 4 weeks from the date of service of
the
order.
Not from the date of submission of the representation. On the date of the representation from them.
Service of the order. This is treated as representation. The petition.
Petition to be treated as representation.
The petition itself shall be treated as
Yeah.
representation and shall be decided as above. This court has not expressed any opinion on the merits since the petitioner has chosen to adopt the above course of pursuing the petition as representation.
My lord, I may have to come second round also
No, they
to
will
seek validity of 15th order.
He appears to be right in a way.
We'll consider that. We'll consider.
That 2015 was only for non-teaching staff.
Please.
He's a principal.
Seal number 10, it is Somasundar Rao. Seal number 10.
Oh. Yes. 230.
Seal number 11.
11 is
Date appeal.
government appeal, my lord. There's a delay, my lord. I will take notice on the delay application.
Pardon?
There's a delay of 217 days, my
Notice.
lord. I will take notice.
26th,
Serial number
7th
12.
January, 28 January.
Serial number 12 also.
12 also same. 13 also same.
Seal number 14. Narsim Murthy. For the respondent.
Please, your lordship. Please, your lords, I represent the appellants. Not appellants who are not predecessor in title of the appellants were the inamdars of 7 acre 8 guntas. Not the predecessor in the respondents 2 to 10, my lord, they claim that their predecessor in title purchased 1 acre out of, my lord, 7 acre 8 guntas. It is a, my lord, service inam land. And therefore, my lord, the Tahsildar, as per Annexure D, my lord, passed an order wherein, my lord, now the learned single judge has, my lord, ordered that the sale deed said to have been executed in favor of predecessor in title of respondents 2 to 10 should be confirmed, though they were not at all in possession at any point of time.
The appeal for the city civil court was against which order?
Please, my lord. Writ petition appeal was filed.
Appeal before the city civil court.
My lord, the district judge order passed by the Tahsildar, wherein application filed by respondents 2 to 10 came to be rejected.
So before civil court, it is competent?
District judge. It's under section 3(2) of the Village Officers Abolition Act. Now, the concurrent findings have now been set aside by the learned district judge. Though, my lord, they are not in possession, that property now comes within the corporation limits. Chikkabettahalli village in Yelahanka, this thing. It has lost its agricultural nature. My lord, though the proposition, my lord, in Bashir Ahmad case, my lord, is sought to be extended. My lord, it has to be, my lord, they were not at all in possession. The sale deed dated 1/1/1966, my lord, was not acted upon. And there was a holding that, my lord, sale deed is null and void. Kindly go to, my lord, ink page 158. May I draw your lordships?
Who are you?
But we are the original inamdars.
Original inamdars?
Yes, of the entire extent. So now respondents 2 to 10 are claiming.
Sale deed of 66 was in your favor? No.
No, according to them, our predecessor in title has executed in their predecessor in title in favor of 2 to 10's predecessor in title.
Land is with whom?
Possession. Land now, several buildings have come up, my lord. It has lost its corporation limits, man.
No, my lords. To
Yes, there is a report, my lord, from the report was submitted. Even report can be called for from the, my lord, learned government advocate. What is the present position? It has lost its, even, my lord, if they are in possession, if sale deed is acted upon, my lord, then they are entitled for, they may be entitled for that benefit. Without examining, my lord, in fact, Annexure D for a moment, their sale deed was held to be null and void. Kindly go to, my lord, page 158.
So where is the order or dated or first order passed by?
Tahsildar,
22/9/17.
22/9/17. Please, man.
Which was impugned before the district judge.
District judge's order is at, finding is at page
85. There it 85.
82. 80, the finding is given, page 107.
Correct. But where is the order which was before district judge?
Before the original order. Original order is passed by the, Tahsildar. It is at page, 118. English translation is, 125. Kindly go to, ink page 135, my lord. But in one civil suit, my lord, there was a finding. Para 3, your 135. Their application came to be rejected.
Who are the applicants? Who are the applicants with Tehsildar?
Tehsildar, my lord, Tehsildar initiated proceedings as per Annexure D, my lord, ink page.
Munir Ahmad, Rafiq, Salim.
Purchaser.
They are the LRs of the purchaser.
Purchase.
So they were not at all in possession. They lost before the, my lord, Tehsildar. The learned district judge called for the, my lord, the Tehsildar also called for the report, wherein it was submitted that, my lord, it has lost its nature as agriculture land, and, my lord, several buildings have come up and road has been formed.
Or learned senior advocate.
May I,
so and so.
may I bring to the notice of this court, my lords, there is I just filing certain documents, sir.
I think so.
Respect of the application file seeking stay, where the appellants have filed an injunction suit as against me, few of the respondents, which your lordship will find from page number 6 onwards.
Nothing to do.
Which has been dismissed.
One of
which
their
says
RFA
that
is
they
also
are not in
pending.
possession. And admittedly, during the pendency of proceedings between the parties, they've alienated certain extent of land in respect of the 12th respondent. Therefore, they are creating third-party rights in
I take your lordship to the order passed by Tehsildar, wherein, my lord, they are found to be not in possession.
Lordship may
Suit is filed by whom?
Sorry, my lord.
Civil suit is by whom?
They have also filed a suit
By
which
them.
came to be dismissed.
They have filed
Our
a suit
suit, my
against
lord, one
me.
of the suit that is pending in RFA, my lord. One of the RFA is pending.
Lordship may kindly have a look at page number 6 of the objections which I've
Or
furnished.
learned senior advocate,
But
so and
RFA is
so and so
pending.
are listed by- Before that,
Page number 6, my lords.
assist by so and so for the appellant. And learned, what is your name? Learned,
Sachin C, my lords.
You are on.
Sachin.
On caveat,
I'm going to file wakalat, my lords. I have wakalat right.
who appears to make submissions stating that he will be filing his wakalat number. The appeal arises out of judgment and order dated 1st October 24, passed by a single judge, whereby the petition came to be allowed and the order stated 2/7/2020, as well as 22/9/17, passed by the
First additional.
learned 24th additional city civil judge, Bengaluru city, and learned Tehsildar, respectively, came to be set aside. By order dated period 22/9/17.
Yes, yes.
Tehsildar, Bengaluru North, into brigade additional, Taluka Yelahanka, Bengaluru. Rejected the prayer of the applicants before it for mutation of RTC entries in respect of the land in question. The case of the applicant before the Tehsildar was that the grandfather of the applicant number 5 and 6 had purchased the land, part of the land out of the total land, even prior to the re-grant order. The case was negative by the Tehsildar, recording finding of fact. Paragraph. When appeal was filed before the district judge under section 3 into bracket 1 of the 3 into bracket 2 of the Karnataka Village Officers Offices Abolition Act, seeking to set aside the order of the Tehsildar and confirm the sale deed dated 16/11/1966, learned city civil judge dismissed the appeal, confirming the findings of the Tehsildar. Prima facie, in allowing the petition against the aforesaid order from a learned single judge as interjected with the concurrent finding of facts. Full stop. A prima facie case is made out. Appeal is admitted.
May I
Learned advocate, Mr. So-and-so respondent tenders certain documents on record, which are certain documents which are taken on record. Full stop. Learned advocate, learned senior appellant would submit that today the entire nature of the land in question has changed and constructions have come up. Full stop. Considering
request your
all the
lordships
above
to-
aspects, it is directed that the parties shall maintain status quo.
Please.
With regard to the subject matter land, and there shall be no alienation, transfer or creation of third party rights by either of the parties.
Yes. Obliged.
Pardon?
Not 2 to 10.
2 to 10.
My learned friend may take notice for respondents 2 to
Notice of
10.
admission notice of admission shall go to the respondents. Full stop. As far as the 2 to 10 is concerned.
2 to 10, I'm
the
filing
notice is
wakalat.
accepted by learned advocate.
And learned government advocate may take notice for.
Respond number 1.
Similarly, learned additional government
Respondent number one.
is accept notice on behalf of
Respondent number 1.
respondent number 1. The rest of the respondents shall be served.
Not present status, my lord, report may.
Pardon?
Present status, they may obtain a report.
Present status?
The learned government advocate may obtain the report from the Tahsildar, so that
Regarding the status of the land, development activities.
development has taken place.
At my lord,
Status
It
quo
is-
should be maintained by both. वहाँ add करो next sentence. Learned additional governor shall obtain the status report as on date in respect of the property in question and place on record of the appeal.
Obliged.
obliged. Still number 15. Srinivas.
I represent for appellant in this case.
Yes.
The appeal is preferred against the order passed by the trial judge. The originally suit is for recovery of the amount, wherein,
Dismissed or decreed.
no. Application under section 8 of arbitration was been dismissed.
Section 8.
Section 8.
Where is that application?
Annexed area, sorry,
Page
annexed
30.
area, D.
It is rejected.
Yes, yes,
Rejected.
yes, it is.
Not is written.
Alla, may I make a, 21st, the matter is posted for finally for the cross-examination.
To seek time.
If stay is not granted means then the appeal will become infractious.
Not complying. So complying section 8, he filed a
Lots, they themselves have filed an application, sorry,
Consider on next. 17th December.
21st is a case posted for finally for the cross-examination.
It is open to the petitioner to appellant to seek time in the proceedings.
No.
Yep.
Twice the matter was been posted. Based on this, this appeal, kindly have it on the Monday, Your Honor, or Tuesday, I shall convince you. Because 21st, they have given finally,
Then this, if the applicant prays for time before the court below where the suit is pending,
yes,
the court shall consider the request in view of the pendency of the present appeal. Right, next.
if stay is not granted, I have to be cross-examined.
They
There
have
is a-
said that if you pray for time in the proceeding of suit, the court will consider the request in light of pendency of this appeal. What can be?
more time, taking a time. One, he filed a writ petition, that can be rejected.
We'll
Like-
consider
They
on
have
next.
filed the appeal.
We'll consider on next. Next.
This is review petition. Bill number 16, Mr. Shrikant MP.
The petitioner, Lord, the petitioner was before this court, saying that, Lord, she's Lord, her claim was that, Lord, she was entitled for P1 qualification. And, Lord, she sought other remedies, Lord, and also she suggested, my lords, alternative remedies which can be provided. My lord, that considering that, my lord, the fee is about 11 lakhs,
my lord, this honorable court comes to the conclusion that, my lord, 10 lakhs as the adequate compensation. My lord, my submission is the actual fee she is paying is 22 lakhs per year, which comes to around 1 crore 10 lakhs, my lords, for the course. And my lords, produce, my lord, the fee receipts also for your lordship's consideration. And the decision, my lords, which has been relied upon by this court in awarding compensation states that, my lord, it is an additional remedy which can be granted to the, my lords, the remedy which can be granted in the circumstances. In fact, my lords, para 12, my lords, of Krishna Sada's case, if I'm permitted, my lords.
So that is the only ground of review that compensation is inadequate.
The other ground is, my lords, I'm denied, my lords, the admission. In fact, I suggested that there were private respondents who are taken, my lords, the sports quota seats, whereas I had to take payment seat.
When you are reviewing the order, you have to choose either of the ground, because both may not go simultaneously as an argument.
Lords,
Whether you insist in the review for admission,
please.
or you say that compensation is inadequate. If you are both, the ground will be mutually inconsistent. Isn't it?
My lords,
You press for the
please.
admission as well,
Please.
and also contend that the compensation is inadequate. So both is not mutually exclusive, at least in
understand.
review application.
My lords, what the view taken, my lords, by the Honorable Supreme Court.
No, that is correct, but you have
Please.
to choose what part of the review relief you are seeking. You are insisting for admission,
Please.
or you are complaining about the inadequacy of the amount determined by the court towards compensation.
My lords, regarding that, my lords, I may, in fact, my lords, I have to
Verify,
take
take
instruction. Tuesday, your lords. Please.
Not Tuesday. We'll go to 3rd of December.
Please.
May I pursue, your lordship? This matter was set for framing of charges, my lord. On 3/10/2023, Lord, an detailed order has been passed by this honorable court. May I read it with your lordships, my lord? On 3/10/23, pursuant to the notice issued. The notice was issued, my lord. Am I reading with your lordship? Pursuant to the notice issued, counter affidavit is filed in this court on so and so. Learned counsel for respondent accused submits that endorsement is issued on so and so, and same is annexed to the affidavit at so and so. It is stated the endorsement that as notified, though there is reference to some factual aspects, the last paragraph reads as under, further as notified by the commission on so and so, in connection with the appointment of so and so motor vehicle inspectors, the petition number so and so filed by you before the Honorable High Court, and about which the Honorable High Court ordered to consider your case as medically fit, dated so and so. As per the order of the High Court, by considering you as medically fit, also for selection process, your candidature considering the same as per rule, reservation also on the basis of merits. On verifying the same, it appears that reservation also competitive examination, marks secured, also the marks secured in the final test, cutoff so and so are as under. And my lord, that is extracted. As per the aforesaid clarification, the reservation which you sought for the selection of the marks secured by you is less than cutoff candidates' marks, and hence you are not eligible. Learned counsel also vehemently submits that complainant was entitled to provisional list and same was quashed. The physical examination of the complainant petitioner was found unfit. As such, the respondent is taking a stand. For these reasons, in order of which the non-compliance is alleged, cannot be complied with. We are surprised to see the approach of KPSC, which is a responsible constitutional body for selection of candidates for public service. It seems that body which is expected to act as an independent instrumentality ought not to have carried any personal grudges against any candidates in general and complainant in particular. We have reason to say so, as the order of division so and so more or less asserts entitlement of the petitioner as the qualified candidate for selection. The petitioner has approached this court challenging the rejection of his candidature on the medical report issued by so and so. Normally, we are not inclined to give details of the order which non-compliance is alleged. But in this case, We deem it appropriate to refer certain details. Rejection of the petitioner was on the ground of his vision impairment and lesser height than prescribed. Initially, this rejection was subjected to challenge by the presenting application before the KSAT, which had dismissed the same relying on the medical. However, the division bench found that in this very report, there are two different opinions certifying the petitioner is free from all. Can I continue? Free from all congenital diseases and deformities. It is also stated, one of the experts that report of the so and so, that I will ignore, my lord. On perusal of the report, division bench recorded the following observations. Then, my lord, I am skipping that also. Medical report now produced before the court. I am reading, my lord, para 8. Now produced before the court by the director so and so clearly depicts that appellant is eligible in terms of eligibility qualifications prescribed by KPSC for the post of so and so. Unfortunately, on the basis of wrong assessment made by medical board, so and so hospital, his candidature was rejected. It is also unfortunate during the pendency of the proceedings before KSAT, applicant should have filed an application to refer the matter to medical board. Same has not been done. KSAT has proceeded to reject the application of the petitioner mainly on the ground of its expert opinion. Therefore, court should not be interfered. When this court appointed the medical Minto so and so Minto hospital, now the report is in favor of the petitioner, which clearly indicates that medical board Bowring hospital is not discharging its duty properly. Now, my lord, I skip that portion entirely. Without expressing any opinion on merits or demerits of the case, we are of the considered opinion that rejection of the candidature of the petitioner made by KPSC so and so on the basis of wrong report of medical board so and so cannot be sustained, and same is liable to be quashed. Then, my lord, provisional list issued by respondent KPSC.
Is the contempt committed?
Contempt is, my lord. Now they are not ready to take me. This order clearly says, lordship may see the last paragraph.
Where is the direction to take you?
Sorry, my lord.
Where is the direction to take?
Yes.
Lords.
Wait.
I was the only ground for rejection was that I am medically unfit, my lord. And I went through the process of medical examination. I was declared to be fit. I was not disqualified because my marks are less. There is a specific positive direction to consider me. Consider my candidature. And, my lord, the consideration is on the basis that my only disqualification, my lord, is now removed. And, my lord, that is why the charges are framed. Your lordships may see, my lord. Thus, we are of the considered opinion, in spite of giving sufficient opportunity for showing bona fides contention to comply with the order, in letter and spirit, accused has not complied with the order, raising various technical points. This was carried in appeal, my lord, before the Honorable Supreme Court. This was dismissed. Same submission was made. Nobody has asked, the court has not asked your candidature to be considered. We are not bound to consider is the consistent stand taken even before the apex court. And apex court, my lord, they withdrew the appeal, my lord, against this order of this honorable court. So my respectful submission is, my lord.
Against which order they want to read?
This order, my lord, which I was reading.
310.
Yes, my lord. 310. Yes, my lord.
They went to Supreme Court.
Yes, my lord. And to say that when there is an endorsement issued, that is sufficient compliance. SLP dismissed against KPSC. I have produced that order also, my lord, on 6/6/2024. I have produced a memo. Can I pass it on, my lord, for ready reference, if it is not? Annexure K, 6/6/24, my lord. Lordship may see. Yes, I'm sorry, one more. Yes, lordships may, lord, the last, I'm sorry. They have been contending that there is no specific or positive direction for me to appoint you. And this stand is negatived, and therefore, my lord, this matter was set for, because, my lord, they are wreaking vengeance against me. There are 600 posts still vacant. They can consider me against any of those posts, dehorse all this litigation. They want to target me, my lord, and disobey this honorable court and risk the contempt. And, my lord, the detailed order on 610. Otherwise, my lord, I would not have read this order because in contempt petitions, my lord, it is unprecedented that the orders of this nature are passed.
Where is this 16/7/21 order?
Yes, 16/7/21 order, my lord. The petition have enclosed.
Karnataka State Appellate Authority.
No, my lord. Yeah, this honorable court division. Page.
The order which is post plan a single judge.
Yes, that is, my lord, page 16, my lord, 16 of the petition. 21st April 22. Lordships may see, my lord, paragraph Roman 4. On ink page 28, my lord.
16,721.
I'm sorry. This is, my lord, the order of which the contempt is alleged of. The division bench judgment is page 16, my lord, 16.
So before the division bench,
Yes, my lord. There is a positive direction.
one of the order impugned was,
Yes, set aside, my lord. The KSAT's order was set aside.
one of the order impugned was 16,721
Yes, my lord.
and 10,122.
Yes,
In
my lord.
review. Where are those orders?
Those orders, my lord, I have also produced the KSAT's orders, my lord. Sorry. This one. No, my lord, I'm sorry, not able to raise hands immediately, my lord. They are part of the, I am so sorry, my lord. In the meantime, my lord, if lordships permit, I'll read this order, my lord, of the division bench. I'm so sorry. I'll get that order, my lord.
What do you say, madam?
The lordships may see, my lord, direction 4. I'm sorry, my lord, I'm not troubling again.
My lords, one submission. The KPSC Commission Secretary has changed again. The KPSC Commission's Secretary has changed again. I would seek accommodation to file objections on IA number 1/24. That is for the additional production of additional documents.
EA number
Yes,
1.
IA 1/24
They want to substitute the accused. These are hyper-technical issues.
for production of additional documents, my lords. I seek to file objections on that. A short date may be given.
I have, my lord, myself
Yes,
said, the
instructions
incumbent has changed and memo is filed. They want to file objection to that. I
Yes,
have
thought
done
it-
their job, showing who is the incumbent KPSC secretary against which they want to file a.
We have sought instructions regarding that, my lords. We would
And
file
lordships
the
may see, my lord, I'm only
objection
persuading
also.
your lordships to see direction number 3 and 4, my lord, of the division bench order. Without troubling your lordships with other orders, my lord. The order passed by KPSC, am I reading with your lordships? My lord, page 27 of the complaint. The order passed by KPSC rejecting the candidature of the petitioner for the post of motor vehicle inspector by rejection list so-and-so is in violation of 14-16-21. Then, my lord, first respondent is directed to reconsider the claim of the petitioner for the post of so-and-so as he has fulfilled the eligibility. Now,
Right. So you are saying that in light of clause 3 there.
yes. If my marks itself was less, my lord, in these petitions, that's what, my lord, the Honorable High Court also says. You should have said it is only an academic petition that we are entertaining. Because even if you qualify physical,
Why you are not, accepting the candidature?
My lord,
There are
I have to
600
seek
posts.
instructions regarding that, my lords. I have to seek instructions regarding that from the commission.
I've produced it. Wait.
My lords, I seek for short accommodation.
There are 600
I'll
posts.
seek instructions, my lords.
Grant you the accommodation, but why you are not considering despite the direction?
My lords,
Why you are not considering the candidature despite the direction?
my lords, the accused number 1 wants to make a submission.
No, you are the lawyer. We are not hearing any party in person. Please don't project any party in person before this court. This court is wary of part in person addressing the court unless they are recognized to be competent to address the court under the High Court rules. Please ask your client to take a seat. You are there, you submit. You are the officer of the court.
I've not been received with the instructions regarding that, my
His
lords.
personal presence was secured only to ascertain that.
Maybe he is not entitled to address the court. Please don't project the party in person. Your
Apologies,
client
my
can
lords.
Project your clients before the court. To
I
argue,
seek
if you are
apologies, my
competent to
lords.
argue, then don't argue. We'll decide the case without argument. What do you want?
My lords, pass over the matter, my lords.
When you will take in?
2:30, my lords.
2:30. 2:30.
Anytime, as
2-3
your
days. 2-3 days. You
my
tell,
lords,
tell your date.
a date, my lords.
You are seeking time.
A date may be given, any date as your,
Tell your date.
my lords, Tuesday.
This Tuesday.
Yes, my lords.
4th December.
Lordships, I'm without job for 25 years. Lordships may-
There must be some reason, Mr.
No, the reason is this, my lord. What they are contending.
Sir, why should they face a contempt?
Sorry, my lord.
Unless
No,
there
they
is a
are saying, my lord, they are saying, my lord, that you have not secured the requisite marks. And you have not secured the requisite marks. You may have passed the medical examination. And, my lord, this was urged before this honorable court in contempt. The honorable court observed, Lord, highlighted that portion saying, your endorsement is only a facade to avoid implementation, because every time the contempt is filed, you will come up with a new ground. You will say marks are less. Sometimes you'll say your medical qualification is not there. Sometimes you'll say you are not under the reservation category. So every time they dodge, my lord.
Rather than taking instructions, you advise your client what to do.
And 400 posts are vacant, 200 posts, additional posts are also created. I'm only.
Advise. The council said that he is not getting the requisite mark. Then what is the remedy for you?
On Tuesday, my lords, the matter may be heard. I'll take instructions also regarding that, my lords.
I have filed a memo. Lord, divorce this litigation also. One post taking, I am not that.
My lords.
Come on 4th December. 4th December.
Before that, my lord, at least. Ships may see.
Better take it.
No, it will all, my lord, evaporate. My prayer is, my lord, now that the matter is, my lord, has reached some logical stage. And it was actually, my lord, this order or this matter was set for framing of charges, my lord. Because I only prayed that, my lord, the matters are not, it can expedite and they can take a decision on that, my lord. I'm only praying that, my lord, because it is framing of charges. They have crossed that phase. Now, either they have to, my lord, the honorable court, because it is merged with the Supreme Court order.
Supreme Court, they have withdrawn the.
Withdrawn. I bow down. They are also aware, my lord, that they have made it a personal issue. The honorable court, your lordships may seem like the predecessor, honorable the Chief Justice said, they have made it a prestige issue that at any cost will not give it. Come what may, we'll face the contempt, we'll go to Supreme. Otherwise, we're not going to Supreme Court against a poor 30 years I'm facing this part.
Kind of.
My lords, senior is also not here. So
Senior is appear. Who appears?
KM Prakash.
Panel counsel.
4th December.
Also, senior counsel PS Rajgopal appears for the matter.
So all are welcome to appear, but 4th. You are also welcome if you are.
No, but lordships may have it at a short day.
Let him her wait.
They are themselves ready to take it up on Tuesday.
Don't put pressure on her.
You
can put
I am
pressure on-
jobless for 25 years. And 2006 also I have been applying, Lord. I've ruined my whole life.
You can put pressure on the court, but not on the council.
I'm at your lordship's hands, Lord. Whatever your lordship.
Find out.
Yes, my lords.
Find out
So I
where.
seek apologies, my lords.
Doesn't matter, find out somewhere. Instead of facing contempt, you find out on your own way you find out. Yes.
Wait.
Number 18, to John Paul.
For the complainant, my lord, we have not received a
complaints.
copy of compliance affidavit filed by the AG on behalf of AG.
Is filed, what is the direction?
Complaints affidavit has been filed, my lord, to consider the
Decide the representatives. It is
to
decided.
consider the representation, my lord, that has been done, my lord.
The only direction in the order dated. April 2024, passed by the court.
Okay.
Was allowing the petitioner to pursue. So he made a representative.
19th April 24, my lord, a request was made.
He made a representative.
Yes.
He did not
Har-
file appeal.
No, my lord, a representation was made on 19th April. We have
The
inspected the
direction of
property.
single direction of the court in order dated 1/4/24 while disposing of the writ petition was to permit the petitioner to avail the remedy under section 15 of the Karnataka Regulation of Stone Crushers Act 211.
That was my.
Or in the alternative, request the authorities to decide the representation. It appears that the petitioner chose the latter course, LATER. And since the representation was not decided within the stipulated time, the contempt petition was filed. Whereas upon notice issued in the contempt of these, the present contempt proceedings, affidavit came to be filed by learned additional government advocate, Mr. Harish, along with the compliance affidavit, endorsement dated 10/10/24 has been produced on record, whereby the application of the petitioner was not entertained and the representation is accordingly decided. Copy of the compliance affidavit along with the aforesaid endorsement of the order dated 10/10/24 is served on the counsel of the petitioner, Ms. So and so, so and so. In your favor, the compliance of the directions of the court has been obtained. The contempt proceedings will not survive. It is accordingly disposed of. However, if the petitioner has any grievance about the merits of the endorsement in question, it will be open for the petitioner to institute in the proceedings to challenge the same in accordance with law and on merits in accordance with law, in respect of merit of which this court does not express any opinion. Right.
Cell number 19. BV Nitish Street.
Hello, this is a petition filed by the High Court Legal Services Committee pertaining to the daily wage workers posted at the residences of the honorable judges in the Dharwad and the Kalburgi benches, my lord. In fact, if I could take my lords to the previous order, it was passed on 27th October 2023. Hello, there are about 64 part-time menials employed in Dharwad, 20 in Kalburgi. After this honorable court's intervention, the minimum wage that was being paid to them has been brought on par with the permanent employees. Now there are 2 interim applications that have been filed where the benefit of holidays that is being given to the general employees, permanent employees, may also be extended to the part-time menials. And this honorable court had directed the government to see if there can be some benefit that can be extended under the Karnataka Daily Wage Employees Welfare Act 2012. This was in October 2023, my lord.
Yes.
Second respondent, it's for the government to tell.
My lord, may I apologize. Could I seek for 2 weeks' time, my lord, to find out what has happened and place the exact status before my lord?
How many daily rated workmen are there? All?
My lord?
How many daily rated?
My lord, when we filed the petition, there was 84. Now, because of age, etc., there are 45 in the Dharwad bench, 26 in the Kalburgi bench. And I'm told that these are not sufficient numbers to assist. And there is a need, in fact. In fact, this court had intervened to ask if the government can create these posts and appoint. They can't expect the high courts to function.
Registrar General, second respondent.
Registrar General.
Yes, please.
In fact, this court has taken notice that the high courts can't be put under pressure where there is no assistance, no infrastructure to help the judges.
My lord, I'll.
Take your, make your stand clear, we'll dispose of. You don't want to. This here in this state, the legal services authority go on filing public interest. They are welcome to file, but sometimes it doesn't become palatable to at least my comprehension.
Yes.
We'll see.
My lord, was filed on behalf of the daily wagers, the part-time menials. They were not getting their, they were being paid 3,000, my lord, per month.
Only the government cannot.
They can create posts, my lords, that would be more regularized and the
These are the
labor
group.
rules can be.
These are the group of employees in the establishment of High Court. And is part of larger group of daily wagers, which may be employed in the state establishment in different. So it is difficult for them to have carve out a subgroup and do a favor.
Yes, my lord. But the ones who are already deployed, my lord, they can't be expected to work beyond certain hours, not receiving pay that is.
My lord,
already
all
given to
the others will
employees.
also start approaching my lords for, so that I'm,
Something can be done for the.
I will.
Obliged, my lord.
When shall we keep? 5th December
Very well.
for the time being.
Yes, my lord.
This seal number 20. Shreyas, 14%. Shreyas, 14%.
Fixing of voice announcement system in the KPSC buses. Has complied with the direction issued by Contempt court. And I filed the compliance report. About compliance on 23rd April. You were required to fix it.
That is audio system.
Audio system
in buses.
in buses. There are 928 buses which we required to comply with that. We have complied with that.
Where is that? Your reply. We dispose of the.
On 23rd April, I filed.
23rd April. Yes, 23rd April. So in all buses, voice announcement system is available.
928 buses were to be required to be fitted. Rest of the buses are in the scheme of scrapping. 50% are gone, another 50% go in the
scheme of
buses which are to be scrapped.
Scheme of.
They are selected for scrapping. About 1,000 and odd buses were meant for scrapping. We were not.
Scrapping.
Rest of it, we have fixed it. Another 500 buses which are due for scrapping, we are not.
Right. Those who are due for those for scrapping, you are not naturally not providing. So dispose of 230, let him come.
My lords, I'm for the petitioner, my lords. I'm
Yes.
the petitioner, my lords.
So we are
Sorry.
disposing of Mr. Party in person. They have complied with your grievances satisfied. 928 buses are equipped with the voice announcement system.
Please, my lords. Please, my lords.
So we disposed of.
Please,
Party,
grateful.
we'll say the party in person appeared online.
Please, my lords.
So give the appearance.
This is number 21. The KH-1.
Appearing petitioners, senior is not available.
My lord, this is just to consider the representation, my lord.
But the PIL is not maintainable, my lord. Appear for the fourth respondent, State Election Commission. They sought a relief against us. PIL is not maintainable. They have to file election petition before the competent court, my lord, to address their grievances.
This is that note in the nomination form, the pendency of proceedings under section 138 of India Act was not mentioned in the nomination form. Not the person who has contested for the election. But after 1 year of the elections, he has come up with this.
Election to which seat?
Election to Dongri Gram
For Gram
Panchayat.
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 Gram Panchayat, my lord.
What is the prayer? It is infectious. Does it survive? Election must have been held. It is of 2022.
Term is still going on.
Prayer 2 may be considered, my lord.
Or he's agreed, my lord, he has to file
Election petition. Yes, my lord.
Dismissed.
1 week times.
Pardon.
Raised time for 1 week time. Raised time for 1 week time. Senior not well.
Time.
Yes.
Who appears? Council appears.
My lord, he files an application for early hearing.
That's right, but now. When your council will come?
My lord, on 12/8/2024.
1 week times.
1 week.
Yes.
Only. To be started on 5th of December at 2:30. Since it was submitted that the senior counsel has some personal difficulty in appearing today. Senior counsel who appears for the petitioner has personal difficulty in appearing today. In conducting the for conducting the matter. Yes, next.
22 discourse, number 23. Mr. Raghavendra G. Gayatri.
Lord, 23, my lord. The instructions are that there has been a review petition that has been filed, my lord.
Dismissed. Review petition has been dismissed.
Listed. 409 of 24.
Yes, 418 of 24.
409 of 24 is my instruction.
418 in this. Dismissed on delay itself. Grant of UGC pay scale.
A week's time may be granted, my lord. Week's time. may be
Intra-court
granted.
appeal has not been filed, my lords. What had happened, my lords, is learned single judge both considered on merit, my lords, and also on parity. Now they filed a review seeking that the parity, that one of the member, my lords, one of the staff who are provided with a similar benefit, they have withdrawn against them. On that note, they have filed the review petition, but court had considered both on merit and also on parity. My lords will find, my lords, operative portion at page 24. of my complaint.
Now you comply with.
My lord, a week's time may be granted, my lord. Sorry, my lord, I was not aware about the disposal of the review petition, my lord. Instructions were that the review was pending. So I will take instructions, my lord. Kindly have it a week after next, my lord.
So and so the petitioner produced before the court copy of order dated 13th September. Passed in the review petition number 418 of 2024 to submit on that basis that the review petition against the order brought under contempt has been rejected by the said order. It was submitted that in that view, the respondents are now finally liable to comply with the direction passed by learned single judge paragraph. In response to this development, learned additional government advocate Mr. This wanted time to verify. First of while time is granted up to 4th December, on that day, respondent shall demonstrate before the court the steps taken for compliance of the order of learned single judge put up at 2:30.
One thing, if I may bring to notice, on 23/2/2024, after disposal of the writ petition, they give an endorsement saying that, my lords, that writ court has passed a wrong. My lords, on the last, on subsequent to that, my lords, they had noticed that, my lords, it is an aggravated contempt and they were told to comply. And they filed review, that is dismissed. This is the development.
Endorsement was passed.
23/2/2024.
What was the endorsement?
Saying that writ court passed wrong order and they are not entitled. I have one copy, which my client gave it to me. In Kannada, my lords, it's- they interpreted writ court's order and, my lords, the facts, the judgment relied by the learned single judge, they said it is not reliable. One copy.
Date at least.
23/2/2024. Learned single judge has considered both on merits, my lords, and also on parity. Now parity they have withdrawn.
With the rejection of the review petition, the respondent authorities stand mandated to comply with the directions of learned single judge and to extend the benefit to the petitioner as directed by learned single judge. At the same time, the court was attention of the court was invited by learned petition that on
23/2/2024.
23/2/2024. Who has passed the order?
Respond number, my lords. My lords, it's respond number 2, accuse number 2, if I'm not wrong. I stand correct. Same endorsement has been questioned earlier. Again, the issue.
Past order dated so and so, interpreting the order of this. Interpreting the order of the act. Since that's all. Comply with it.
I will come.
Next time I'll available the translated copy also.
Number 24, Geeta Devi, MP.
My lords, I appear for the petitioner in this case, my lords. My lords.
The earlier counsel who was on record has delivered a baby, so therefore I'm filing an NOC wakalat today, my lords. Kindly give me 2 weeks time to file my reply in this matter. come on this record only this about the.
My lords, they are aware of this matter from 4 months, my lords.
My lord, I filed my wakalat only in the trial court in GNWC in September 25th, and they're telling that I've been there on the. This matter I'll file. NOC wakalat.
Ma'am, your
Mandate for me to file my reply in this.
my lords, the client has already received the copy, my lords. We have in person served the client. The respondent herein he is aware about the matter, my lords. And
Passport, direction for passport.
yes, my lord, this is a passport matter, my lords. My
There
lord,
is communication made on email in respect of him coming, and there were certain things that he had mentioned. They do not see all these things and file a petition just for on basis of some.
my lords, if I may submit, my lords,
We'll give some time.
my lords, page number 20 of the order, my lords.
13th December. Let him rehearse sometime. I'll be ready by that day.
My lords, it may be taken as finally, my lords.
Pardon?
My lords, it may be taken as finally the objections.
What? Final chance for objection. Final chance for objection. But there is a chance.
December 25.
Right, my lord.
Vijay Kumar ke.
Hearing for complaint, my lord.
My
Direction,
lord,
my
for
lord, was
2 weeks' time, my lords, the authorities are verifying as to whether the sites are available for allotment to the complainant.
Lord, direction, my lord, was given long back in the month of 14 September 23, more than 1 year.
Request of learned respondent, Mr. So-and-so, who states that the authorities are verifying
The availability of the subject sites.
availability sites 10 or 2.
Lord,
Any date, my lord.
only once. 2001 acquisition of land,
Let them
allotment, my lord. 2023 order. In spite of that, we paid the allotment.
Don't write like that. At the request of learned advocate, Mr. So-and-so, for the respondent, 10 or 2.
Please.
Date may kindly have it on date may kindly fix, my lord.
It will be given 13th in December.
Grateful.
December 26.
Appearing for accused.
Chandra, yeah.
Lordship, we have received the wakalat of accused number 3,
Yes, the
Lordship.
petitions.
We'll file it during the
14th
course of the.
14th December.
Acha.
December 27.
Yeah, for the third accused, my lord.
Yes.
I'm appearing for the fourth respondent in this matter, my lord. I'm appearing for PFRDA. The petitioners have alleged contempt against PFRDA also, but then in the common order, which is being the basis of this contempt petition, there is no direction against PFRDA, my lord. The petitioners may be required to delete PFRDA from the petition. It's paragraph number 27 of the common order, where the directions have been given to respondent number 1 to 3.
Formal party.
What is the breach?
What is your worship?
What is the breach?
Contempt, writ petition is at page number 10, your lordship, writ petition.
Make one submission, my lord. My lords, the university has preferred an appeal
Preferred
against
an
the
appeal, your
order of the learned single judge. Those appeals are listed at serial number 57, my lord, today. Therefore, I request my lords to kindly connect the contempt petition along with the writ appeal, my lord.
Yes,
Maybe taken up to.
There is university as preferred, only university as preferred.
University preferred the appeal. Let this contempt petition wait
My lord,
to be posted on 14th December.
Please, my lord.
my lord, may the request on behalf of PFRDA also be considered, my lord, because there is no direction against PFRDA in this matter.
On 14th, you need not come.
My lord, I'm only requesting that the petitioners be directed to delete PFRDA because
even their representations have been to the respondent number 1 to 3. They have not sent any representations even to the respondent number 4.
We're exempting you. You get another court on the next.
Sorry, Mr. Chairman.
My lordship, serial number 28 also same, your lordship, 28. And 45 also same, your lordship. Because the all are connected, 45, your lordship. Much other.
On that day will come. On that day will consider your release.
Yes, my lord. Yes. Grateful, my lord.
14 to 11. 45 also. Notice was there.
December 29, Rakesh Kini. 29.
Yeah, accused your lordship. On 12th, I have received the notice. Today, I filed the Vakala, Prakash.
Time.
Yes, I'll be present.
December 16. At the request of Law and Order, Mr. So-and-so, who would be filing Vakalatnama and taking.
Already filed.
Who has filed Vakalatnama? Our will take instruction for the next day. Yes.
Number 30, Sudesh Kumar Acharya.
Complaint. Last date of hearing, AJ took time to file complaints of that, my lord.
Complied with.
Not.
Lord, I'm seeking 2 weeks accommodation, my lord, and appeal is being filed.
17th December, as requested by learned additional government.
31 urgent, serial number 32, to TP Mutana. 32.
Nobody is there.
I appear for the apparent, my lord. This is the case where my lord, the disciplinary authority imposed the punishment of dismissal. And the learned single judge has modified the punishment of dismissal to compulsory retirement, my lord. Now here, the respondent number 2 is sanctioned 337 tractor loan with so many irregularities. Even, my lord, that legal report has to be taken for a sanction loan. He used to get a legal report from the dealer, Mahindra and company. Dealer will come to give the legal report, on the basis he will sanction loan. And that the regional office, that higher authority, my lord, he instructed him. There are so many complaints, you stop giving the loan. After giving instruction also, he given 85 loans. Ultimately, my lord, the entire loan is, because there are no securities and many loans that is bank settled, that 9.78 crores is the actual loss, my lord. But this learned single judgment has come to the conclusion there is no loss to the bank. And even though inquiry has been conducted as per procedure, there is no loss. And this person has not committed any misconduct earlier in his service. On that basis, sympathetic ground, my lord, this punishment has been modified to the compulsory retirement. Your lordship may kindly see, my lord, that Honorable Supreme Court in recent judgment also says that sympathy or that no loss cost to the bank is not a matter to be considered. But here that inquiry has been conducted and all the procedure has been followed, and that respondent 2 has been given opportunity also. And now, my lord, this is the case, my lord, that and
We issue notice.
yes,
Notice written now. 18th December. Not understanding what they are arguing.
Number 33. Srimati Rupa Rai, party in person.
My lords, I'm appearing for the petitioner party in person. I was instructed to appear, my lords. There's some inconvenience. Also, I'm here to apprise my lords that there is a same matter arising from the cause of action challenged by the respondent in the Honorable Supreme Court. I will kindly ascertain so far as the matter is concerned, my lords. Kindly, I pray my lords for a short accommodation, my lords, so far as this matter is concerned.
I appear for accused.
When do you want?
I appear for accused, my lords.
2 weeks, my lords, if I'm allowed to kindly ask.
My lords, in the present contempt, my lords, they have alleged that, my lords, we have violated the order dated 18/10/2022 passed by the learned single judge. My lords, pursuant to that, my lords, we have complied with the order. However, my lords, in the present complaint, my lords, this is disposed of contempt, my lords. In the present contempt proceedings, some certain directions were issued to the officers, my lords, to comply with. We have complied with, and my lords, even the arrears of maintenance, it's a dispute between husband and wife. In that, my lords, we were directed to pay the arrears of, my lords, the maintenance allowances, which we had, my lords, initially awarded. And, my lords, we were directed to issue, my lords, the dependent card and medical card as well, that are complied with. Insofar as, my lords, the quantum of maintenance is concerned, my lord, she has already challenged that by filing writ petition before the learned single judge. Lords, this is, since this is disposed of, my lords, contempt proceedings, so nothing survives for consideration is my respectful submission. If she is agreed, my lords, let her pursue, my lords, her remedy before the learned single judge, my lords, in the pending writ petition.
My lords, I'll seek for time kindly, my lords, if I'm not asking too much kindly, my lords. I'll have to secure
Unnecessarily-
instruction.
In the disposed of contempt, my lords, applications are after applications are being filed. My lords, we were directed to comply with that certain directions also, which we have already complied with. I am filing a memo to that effect as well. Insofar as maintenance is concerned, my lords, there is no arrears as on today. Every month on 30th or 31st, she is, my lords, getting the maintenance amount. And moreover, my lords, the officer, her husband is, my lords, now he is not working with us as he is retired from, my lords, the force. Kindly see, my lords, order dated 24/11/2023.
Something remains to be done?
Please, please.
Something remains to be done?
Nothing to be, my lords, further complied with, as my lords, arrears are also credited to her account, my lords.
Yes, Mr. Patil.
My lord, so far as my client is concerned, I was instructed to appear. My lords, the matter is challenged before the Supreme Court by the respondent side, my lords. So I kindly seek for time, my lords. I'll secure instruction and I'll do the needful, either filing a memo in the counter as I pray, my lords, my lord.
We listed on 18th December.
Deeply obliged, my lords. Deeply obliged.
At the request of party in person, learned party.
Grateful.
This is number 34 for the complainant, my lords. I've been served with an order sanctioning pensionary benefit, my lords. Now, another within 1 month, the monetary benefits have to be released with the order of the division. This honorable court, my lords. That portion is to be complied.
My lord, I'd like to file this order wherein they have approved the sanction for pensionary benefit. They have approved the sanction for pensionary benefit. I'd like to place that order,
What is the order?
saying that the government has approved
Approved.
the complainant for pensionary
There's a
benefit.
direction by the division bench, my lords, that the monetary benefit should be released within 1 month therefrom. The composite directions, two
That
directions.
will done. Goes to the memo dated 15/11/24 filed by learned additional government advocate Ms. Shweta Krishnappa. Reads to state that the respondent as Undersecretary to the Government Animal Husbandry Fisheries Department has passed order dated 13/11/24 sanctioning the pensionary benefits to the complainant the K. 3D Krishna Reddy. Copy of the state government order dated 13/11/24 is produced on report. This translated version. Also. Review of the direction of learned single judge is complied with. The representation was to be considered for the purpose of grant of pensionary benefit to the petitioner. The same is considered and has turned out to be in favor of the petitioner. Also. That's all.
My lords. Within 1 month, they have to release. That's the order of the division bench, my lords.
At this
20
stage, learned advocate states that time may be stipulated for payment of monetary benefits arising from the order of learned single judge. Since in the original order of learned single judge dated
division bench.
24th February, 24th January 17, period of 1 month was contemplated. It is hereby provided that the benefit shall be given to the complainant within a period of 8 weeks from the date of receipt of the copy of this.
Please. It's a division bench, my lord. Division bench.
Division
order.
bench.
Division, not learned single.
Much obliged.
Great.
M. Krishnappa.
Nobody is there. It will go to 19th December.
We have complied with, my
30.
lord, serial number
Which one?
36. There's an interim stay with regard to the issue was to publish the seniority list. There's a interim stay after the preliminary list was published. So we are ready, the government is ready to publish the seniority list, except that there's a stay in the matter. And we have filed a compliance report accordingly.
Who appears 36? Nobody appears. It will go to 19th December.
Thirty-seven urgent. Number 38 to P. Mahesh.
7 in a date, I'm not informed by the time is taken, my lord. For compensation, 81, my land is acquired, my lord. Even though the direction issued by the learned single judge. 37.
34.
And they have agreed to pay. It was a consent order, my lord. Before June 2023, they were supposed to pay the compensation. My land is also used for.
Who appears?
State is the deputy commissioner is the party man, Mysore. Only on being agreed by the deputy commissioner, my lord, this order was passed. And it was agreed to pay within 3 months from the date of the order. Order is dated, my lord, 6th March 23. They were supposed to pay the amount within 3 months. And I was supposed to execute the registered sale deed even though the acquisition is not completed, they have used and allotted to third parties and they have constructed the houses. So we don't want to disturb the beneficiaries, my lord. We agreed for and objections are also not filed, my lord, from 1.5 years.
Yes, ma'am.
My lord, this is the Karnataka Housing Board.
Not housing. Deputy Commissioner.
1160.
You saw notice. Notice is not issued. Issued. Notice is issued.
Let me seek instruction.
Press notice to the unserved respondent number. Press notice to, though notice is issued, respondent number who is not appearing.
No, it is served, my lord. They took time to file objection. The accused number 2 has filed, but it is with office objection. Accused number 1 has not taken any steps to file objection.
Take instance.
Please.
16th of December.
16th.
16th of December. Number 38 to P. Mahesh.
Here for the complainant, my lords, I've just received the compliance affidavit, my lord. The lordships are to grant me a week's time, my lords. I'll seek instructions and I'll make.
Compliance affidavit is filed.
Yes, my lord.
Please, my lord.
It's dated 7/2/24. Served a copy.
I just received it, my lord. There are about 31 complainants, my lords. I'll have to seek instructions from them. My lord.
Release of award of damages.
December 14th.
Obliged.
Much.
December 13.
38, my lords.
December 13.
Very well. Obliged.
Number 39 SB Mukanappa.
Appear for complaint.
Serial number 39 and some other matters, my lord. May be taken up at 2:30 along with list number 2, my lord.
2:30.
Serial number 39,
Copy
40.
was not served in this manner.
39:40.
Compliance is being carried out, my lord. 39, 40, 46, 59, 60, 62 and 68, my lord. I'll pass on the list.
Give number.
I'll pass on the list. Forty sir. 40 also.
41 urgent, 42 urgent, then 43.
I appear for the complainant, my lords.
62.
That is an unfortunate incident, my lord. What has happened in this present dispute? There has been a contempt of the court itself, my lords. If my lords may kindly peruse
Need not wait now.
on 11/8/2023, my lords, which is at ink page number 40. At annexure A, my lords. Apologies, annexure D, ink page number 40, my lords. The respondent accused was directed by the Honorable Trial Court to have the child present before the Honorable Trial Court, as well as comply with the orders passed earlier itself, my lords, wherein, if I may be permitted to read on 11/8/2023, my lords, ink page number 40, it says, both the parties and the councils are present. A memo filed with enclosures, conciliation also held. Respondent is residing in Bangalore, but child is residing with her father in Madhya Pradesh, where petitioner was denied visitation rights. To enable the petitioner father to exercise his visitation rights, the respondent is directed to bring the child on 11/9/2023.
Appearing on behalf of the accused, my lord.
In fact, the humble submission, my lords, till date, the visitation rights by the complainant has not been complied with the accused itself, my lords. If I may be permitted to pass on the WhatsApp call records as well as the video call records, my lords, that clearly indicates and showcases that despite consistent and persistent calls made by the complainant, the same is unanswered. And even if it is answered in a few instances, my lord, the child is not shown to the complainant. I may be permitted to furnish the copies.
If I may make one respectful submission, my lord. If I may make one respectful submission, my lord. A senior counsel is not available today due to a personal inconvenience. If I may request for a short date, my lord.
29th.
Grateful, my lord.
Please.
As it was submitted on behalf of the respondent that the senior counsel who would be conducting the case is not available today.
I will also comply the office objections in the meantime, my lord. I'm so grateful, my lord.
Much obliged.
Number 44. Srikanth VK.
I'm for the accused number 4, man.
I'm for the accused number 3, my lord.
I'm ready with my reply statement to the complaint. I'll serve a copy on the complaint and file it in the office. Then the matter may be considered. I'm ready with the reply statement.
Filing compliance.
No, my lord. Accused number 4, man.
You are filing what?
Reply to the complaint. Complaint.
Compliance if you are filing.
Filing a reply to the complaint. I'll serve a copy on the complaint.
My lord, he says he is ready with the statement of objections.
Filing reply.
Yes, he wants to file it in, that is what. But they have also filed a rejoinder in the meanwhile. I have filed my statement of objections. They have filed a rejoinder. I would like to file my reply to the rejoinder because it runs to about 390 pages of rejoinder. The petition itself is about 130 pages.
But your lordship, but just one, there's urgency to hear this petition, your lordship, because the same accused has filed for dissolution of the company at NCLT.
If that, if a company is itself is dissolved, then your lordship,
What is the direction? Tell it. What is to be complied with?
your lordship,
No, there is nothing to be complied, my lord. They only allege that an undertaking that has been given before this honorable court at the time of hearing of the writ petition while passing the impugned order, while passing the interim order, has been, it has not been acted upon.
Or it is one time standard. January 28. Next.
your lordship, and I may be permitted to reissue notice to respond to accused number 1, because now present director by name Bhujanga Rao has took the notice for the company, but he has not represented the company.
Government is there.
No, company.
Company, number 1.
Yes.
The request of learned review of the petitioner, this one shall be served afresh. Notice shall be issued by the registrar to respond on return alone. Yeah, date, void date. 28 January. 28 January.
Number 45. Mr. Venkatesh TS. 45.
January, 28 January, 45. None present on behalf of the petitioner, stand over to 28 January.
46 will be along with the list number 2, so number 47. The Keshavamurthy B.
Same order, 29 January.
Number 48.
Lord,
AJ Srinivasan.
I appear for the complainant, my lord.
Yes.
This is regarding the payment of gratuity, my lord, to retired professors, my lord. They have not received it to this day, my lord.
Who appears?
Well, complaints affidavit has been filed.
Given copy to the council.
Please, I'll furnish the copy, my lord.
My lord,
Complaints.
even, my lord,
21st
even-
October, it has been filed.
Compliance affidavit is filed, Mr. Council. Have
My
you
lord.
got the copy? Have you got the copy?
no, my lord, I have not received it.
By
My lord,
learned additional
They have
government
received the
advocates
payment, my
that
lord.
the
Demand draft is filed.
Compliance affidavit is filed. According to learned senior counsel for the petitioner, he has not received the copy. Therefore, learned additional government advocate may supply the copy of the affidavit again to the council within 15 days, put up on 28th of October.
Payment
My
has
lord,
been made.
just one submission, my lord.
Yes.
What has happened, my lord, is they have, the respondent number 3 has not fully complied with the order because they have only recovered the gratuity, my lord, but
We'll
they have
consider.
not paid it to me, my lord.
So submit on when you appear.
Very
Yes,
well, very
next.
well.
This is number 49. Mr. Venkatesh Sarvati.
I have received copy of the affidavit stated to be a compliance affidavit, which is not a compliance affidavit. But I'll file my rejoinder. Not but the direction was to issue a occupancy certificate to the petitioner before this honorable court. But that even not confirmed not before the honorable Supreme Court. Writ petition, writ appeal, then Supreme Court. Now they are filing this compliance affidavit saying that they have issued an endorsement. In that endorsement, they say you give up certain portions of the land. Thereafter, will issue compliance occupancy certificate. So that is not the tenor of the order of the Honorable Apex Court, not which confirms the orders passed by this Honorable Court, not coordinate bench, and not the. I'll file my rejoinder not a week's time in the fact.
16th December.
Published. Great.
December 50. Mr. M.K. Thomas, 14%.
Live. person was not present. Put up on 29th of January.
Number 51. The Narsim Rajesh case.
None is present for the appellant, stand over to 30th January.
Number 52. Mr. Chandrakant Argole,
52 is urgent. Next. Same order. 30th January.
53 urgent, seal number 54.
For the appellant's counsel, Lordships had heard this for some time, and they should notice on the delay. They've taken out the notice, but the contesting respondent would be the Bangalore Water Supply and Sewerage Board. There were some issues regarding whether those charges can be applicable to a sanitary connection when the regulations itself require us to set up an STP. We don't even use the connection. So the question of quid pro quo and fee is involved.
Not appearing, nobody appears.
No one has come, no one for the
Getting
BWS.
service.
Could we take out service on the counsel who appeared for the?
Therefore, the appeal may be listed only after the service is effective.
But could we take out, could we serve a copy on the counsel who represented before the learned single judge for the board?
In the meantime, it will be open for the counsel.
Grateful.
Appellant to serve copy to learned advocate who appeared before learned single.
Grateful.
Seal number 55.
Here for the
The
petition.
commercial appeal.
For the appellant.
maintainability.
Lords, regarding maintainability, my lords, if I may draw your lordship's attention to section 13 of the Commercial Codes Act. Matter is listed for on the aspect relating to maintainability, my lords, of the appeal. It's arising out of order 7 rule 10, my lords. The application came to be filed by the defendant.
Come on, 26. 26, give the bid.
26. Seal number 56. Furniture of process fee, etc.
Government appeal, my lord, we need to take fresh steps with regard to the notice.
Has to be
Respondent
taken by learned additional government for to south.
My lords, 56.2, one more writ appeal is pending for the same.
Purpose time is granted, stand out to 28th of January. Yes.
One more writ appeal is pending for the same subject matter. It may be connected with this.
It appeal number.
Writ appeal 630
Yes,
of 2023.
Seal number 57.
Much of them.
58, no, 57. 57, yes.
Then, have date. 14. Seal number 58, the office objection matters. The Murugesh V Charity.
Complied, my lord. Needful done, my lord. Complied.
Pardon?
Complied, my lord. Office
Learned
objection complied, my lord.
advocate for the
Needful.
appellant says that office is not complied with, the official verify. Full stop, if the office provisions are removed, the appeal shall be listed for admission here. Next. Within 2 weeks.
Seal number 59, 60, along with the list 2. 61 urgent, seal number 62, along with list 2. Seal number 63. It's office objection, along with council submission. Mr. Janardhan G. 63.
16th November, 16th December, 63.
64, Mr. Murthy K.
16th December. None present, 16th December, none present.
Number 65, Mr. BC Venkatesh.
Same, none present for the applicant, petitioner, 16th December.
Number 66, P. N. Anjareddy.
Appear for, let the dispensation you last me kindly, 190 pages are there. Only the number of connected matters were disposed of. Cost title itself runs to 100 pages, more than 100 pages. Only relevant portion I have filed. The guest teachers working. Full judgment is not filed. That may be dispensed with.
Highly.
190 pages are there in blood.
So what? Unless office officer complied within 3 weeks, the petition shall stand dismissed automatically. Chalo, next. Whatever page, we are not concerned. It is your business.
Number 67, Mr. Mahesh Arkalgud Srikanth. 67,
All to be adjourned after December, January, in the week of. Nobody is present in the week of 21st. Between 21st to 25th January.
68 along with list 2, seal number 69, Mr. Sridhar G. Number 70, Mr. Srinivas Murthy SR.
Weeks accommodation.
Week's time is granted.
Seal number 71, Mr. Abhishek NV.
We are free, complaint, madam. Yeah. As to why accused number 2 and 4 have made a party, the direction is against the entity, BESCOM and KPTCL. A1 to A4, all are responsible for compliance with the order. That is why I've read them as a party and the specific pleading also in the complaint. The order was to comply with dispersing with the pension and other retirement benefits of the petitioner within 8 weeks. After I submit a representation, that has been done to all the accused, despite which
28 January.
my request notice to be issued me.
No, what are saying? Comply with the office objects.
I've complied, my lord.
This is not our job, Mr. You go before the registrar judicial to examine the office objections and complaints.
May I make one
Wasting the
submission?
time for all these matters. Yes, next.
Number
This
72.
is not our job. This is the court of first job to examine your office objections.
No, my lord.
So go to the
I'm only
registered
making a
judicial.
submission that they're also responsible.
We don't entertain such submissions. We have no time for this miscellaneous work. Yes, next.
Number 72.
This system we are going to scrap in this high court. What is this? You're wasting your time in making submissions about the office objections. You go before registered judicial. We'll change the administrative whole setup. This is not the way to waste the time of the court. Next.
72, Mr. Sheikh Ismail Zabiullah.
Appear for the petitioners.
What is it?
Complainant. The office.
Comply with
objections-
your objection.
No, Lordship, all the office objections have been complied.
Learned
So far as
complied with.
two office objections.
It is not our job. You satisfy the registered, learned advocate shall satisfy the registered judicial about the compliance of the office.
One humble submission, Your Lordship.
As claimed by him. We are not going to examine the office of this. That is 101% certain. Next.
Number 73, Mr. Abdul Nazir Patara.
No password, 28 January. Yes, next.
Number 74, Mr. Gautam Raghunath.
Serial number
74, Mr.
74, yes.
N. Gautam Raghunath.
So in all our office objections, so in all matters, common order, time is granted for 4 weeks. Full stop. Registrar judicial shall examine the compliance within that time. Or interim order, wherever it is there, it may be extended.
Serial number 85, my lord.
Yes.
Lord, there, my lord, there is no office objection. There is a note, my lord, a submission, because they have made deputy registrar evaluation as a party. My lord, under the
We are
provisions.
concerned. You go before.
No, I have made a submission, I have written a submission.
No submission, no submission.
Serial number 10 total.
No submission on office objects.
List number 2, my lord, could be discussed.
Yeah,
What is not meant for removal of office objects.
no, my lords, objections are already complied, my lords.
My lord,
Court officer. Hello?
Lordship.
My lord, may I mention a matter?
Yes, my lord. Very well. Yes, my lord. Yes. Very well. My lord, that is a challenge in serial number 22. Yes.
Lordship.
My lord, I have filed an IA in 5 and serial number 22 coming together. Yes.
Lordship, serial number 73, I missed out because due to I could not reach the code because of claustrophobia. Serial number 73, contempt petition, I missed out because I could not make a submission in full court. Contempt petition, serial number 73, has already been called out, Lordships. Kindly accommodate at the end of the list.
Yeah.
Lordship, due to claustrophobia, I could not climb the stairs and reach one.
List number 3 for pronouncement of judgment in writ appeal 1397 of 2024. Sridhar Prabhu.
Correspondent 1 and 2.
Appearing for the appellants in the matter, my lords.
Writ Appeal 397 of 2024. The conclusion reached by the learned single judge while dismissing the writ petition cannot be faulted and interfered with. In that view of the order, other contentions renders academic. The same do not merit consideration. No error can be booked from the order of the learned single judge. Accordingly, writ appeal is dismissed.
Please, my lords.
Passover matter in list number 1 till number 10. Sir Soma Sundar Rao till number 10. Number 73. Abdul Nazir.
Lordship. There is an office objection which needs submission to be made by me with regarding the fifth and sixth parties who have been made as accused in this case. It is due to the order which they have tried to tried to go in for an execution proceeding before, by filing a writ petition, before single judge, who has accepted their plea and allowed the particular writ petition, Lordships. Lordship, may kindly see in page 30, that is the order of Tahsildar, wherein he has initiated 192A proceedings. Lordship. Lordship,
Which are the directions under contempt?
directions under contempt is the document which is there with the execution.
Show
of
us the direction.
Lordship.
Show the direction which are to be completed.
Yes, Lordship. Annexure E, Lordship.
Page.
73.
Page 38, Lordships.
38.
Yes. This is the order of the single judge. The single judge has categorically told that the para number 3, Lordships. If I may read.
What is that? There is no direction.
Lordship, further the learned HTGP of respondent number 1, upon instruction submits that the impugned order will be implemented only against the persons who are party to the proceedings and not against those who are not a party to the proceedings before respondent number 1, who is the Tahsildar or respondent number 2 here before Lordships. If anybody has to be evicted pursuant to the impugned order, the same will be done only after affording them an opportunity to be heard.
You are not a party.
I'm not a party, Lordship. Lordship, kindly see ink page 30, kindly. Kindly see ink page 30, Lordship. That is the order of the Tahsildar. Lordship, may kindly see the appellant, who is Mr. Ramesh, does not have an address at all. And the respondent there is Azmatullah Khan. There is only one person who is the respondent number 4, accused number 4 in this case. Now, what they are doing is with the help of this particular proceeding, they are coming and demolishing our houses here, the residents of that particular area. I am one of the residents there. The contempt lays for everybody. Whoever if this particular order has to be executed, has to be given an opportunity.
Disposing of the writ petition by order dated 23rd June 2023 from a single judge. While dismissing, a single judge observed the following in paragraph 3 on court paragraph 3, page 38. The case of the contempt petitioner is that what is the property? Residency property.
All residents of that area. Even I am also one of the residents.
That he was not a party to the proceedings before this number 1. That's the Tahsildar. So submitted that as per the directions contained above, only those persons who are party to the proceedings could be evicted. And the other class and other persons who are not party will have to be afforded opportunity of hearing before they could be evicted. Full stop. It was no opportunity.
No opportunity is given. They are straight away coming and demolishing.
Submitted that the contempt is committed by the number 1 by seeking to evict the petitioner who was not a party, and that too without giving any opportunity of hearing. Notice returnable on 4th December.
Lordship, the the area is under law and order has been compromised, Lordship.
In contempt, we can't pass an interim order. You file a mandamus if you want interim order. We keep earlier, 26th.
So number 77, Suresh TS.
Your Lordship, the matter that your Lordships came to partly allow on the last occasion, last week, it's the same matter, your Lordship, the same petitioner, the same survey number. Just give 2 seconds. Lordship, this was not listed on that day, wherein your Lordships have directed that they give us a notice and we have heard.
It is identical.
Identical, the same party, the same survey number. It's just the two separate notices were given in view of the fact that there were two licenses. That's all.
Your not date of notice will differ.
The date is not, sorry, same.
Same. Date of notice is also same.
Please, Your Lordship.
Survey number will differ.
Survey number is also the same. License that they gave was different. One was for 4 acres, one was for 3 acres. What Your Lordship is already disposed of is the 4 acres. What is left is 3 acres. 3.2 acres. This matter, that's all.
Just prepare a sheet and say what is the difference. And have pass over to court officer.
Please, Your Lordship.
Disposed of. Who will appear?
Obliged.
These two.
List number 2. Number.
Mr. Shetty, that dam safety matter is kept on 19th.
Which matter?
Dam safety matter.
Please, my lord.
Because one of the application is not notified.
Please, my lord.
So all can be called civilly.
I'm sorry.
You just ask your colleague to convey to Mr. Naganand.
I'll
My
do
lord,
that.
it's conveyed, my lord. It's conveyed.
Convey
The
it.
colleague-
19th, my lord.
So we'll ask them to appear before you on 21st.
Please, my lord. Well, we'll do it and let the time limit 30th be retained the same thing, my lord. We won't ask for, have instructed them.
30th.
Of your lordship, in the morning I told.
Answer. In Angulu, but-
19th to appear, decision to be taken by 30th is what, your lordship has said 19th to hear and 30th to take, within 30th to take a decision. Let the 19th be transferred to 21st, decision by 30th may be retained.
We'll be able to.
We should be able to, we'll not, just out of 8 applications, only 3 people are there. We'll just have a meeting and we'll close it. In fact, I think question of livelihood, so we'll consider them. In fact, contempt matters.
Contempt will keep for orders, reserve for orders.
Please, my lords. And insofar as what we have done is rest of the 42 cases are listed, my lords. We have filed a compliance report in all the 42 matters, my lords. So.
I think it's in the list to be called.
So we call out cost.
Serial number 3. To Kiran Kumar DK.
From
Serial number 3.
Who appears?
To Kiran Kumar DK.
This case directed to body.
40 has been done.
Body.
My lords,
Not filed application. Not filed application.
this matter, the direction is by the learned singer just to do the body. That has been complied with, my lords. So we have given endorsement issue. Really, I'll go again. The main content may be disposed of, my lords. In fact, my lords, if we have any suggestions, my lords, we'll, from the state side.
Only thing that shall we dispose of in the absence of the advocates?
It may not be probably. One opportunity maybe.
Filed my synopsis, my lord, and that's what I'm provided my input. I'm appearing for the.
Who's appearing in the main
petition. I have provided, I have filed my synopsis.
What is the, there is the
Synopsis I have also suggested.
We'll incorporate it. We are not disposing in just, we are reserving the judge for judgment.
Can I make?
You already filed it.
I have filed.
Can I look at it and give further suggestion, not oppose them?
You can give on whatever.
I'll
you
just
want.
place further.
You can read after reserving today, you can give by 21st, 22nd.
I'm grateful to my lords. Only assisting your lordships, my lord, nothing.
You can welcome. The only direction in the order dated 24/23 of learned single judge which is brought under contempt jurisdiction, was to direct the respondent number 1 and 2 to undertake the exercise of deciding the representation of petition dated 16/9/21. Full stop. In the compliance affidavit filed by the respondent, it is stated that it is stated as under quote paragraph 3. Full stop. The above marks compliance of the order. Learned advocate for the petitioner, however, is not absent in that to put up at 2:30 on 19th of September. Yes, next.
Number 4, Mr. M. Shivprasad. Yes, Shivprasad.
My lords, in serial number 4, my lords, there was a representation to be considered was the direction.
Yes.
BD has complied and issued an endorsement dated 17/7/23.
The file affidavit as well, ma'am.
17/7.
My lords, 17/7/23.
Nobody is there.
It's complied.
Learned,
Yes, Shivprasad.
here Advocate General will be appearing in all matters or not?
My lords, the AG will appear.
Will be appearing in all these matters?
No, man, I won't be appearing. Only for the purpose of complaints, I thought first matter.
Learned Advocate,
Pratima Onnam.
Learned Additional Advocate General Ms. Pratima Annapura stated that the order is complied with as the representative is decided and endorsement
By endorsement
Use-
dated 17/7/23.
is issued by the
BD has filed
competent
affidavit.
authority dated 17/7/23. Full stop. Since learned advocate for the petition is not present, put up at 2:30 on 19th.
Please.
Yes.
Number 5, Sharath S. Gowda.
Appear for the complainant, Lords. Lords, the state has filed an affidavit. I have not been supplied with a copy of the affidavit, Lords.
We have served it, my lords. I can file it, give a copy also again. We have complied and endorsement is issued.
I have not been supplied with a copy of the affidavit, Lords.
I'll serve
Complaints.
again, my lord.
I'll
We have,
just-
before filing, we serve it only and we file. If they have not received, I'll have it filed, give a copy to them.
I have not received.
So 19th at 2:30.
Please.
Still number,
This also you can make a separate list. Same.
still number 6,
19, not 2:30, 19,
Lord,
number 2.
Even in this, it's complied, my lord. Serial number 6, BDA has complied.
2:35. Still number 6, Mr. Ashok Patil.
Lords, now only they served the
Also,
reply, my lords, I requesting to have it hearing.
Now, what is the order? Let us see. What is the complaint? What was the order?
Lords, to file reply, it has been posted, my lords.
Application dated 1/12/18.
Refund of excess amount is what they're saying.
I requesting to have it next week, my lords. This is the case of the refund of amount, my lords.
No. The only direction in the order, the only direction in order of learner single judge dated 12/12/22 was to direct the authorities to consider the application, public representation dated 1/12/18 of the petitioner within stipulated time. In the compliance affidavit filed by the respondent BB Bangalore Mahanagarpalika, endorsement of the order
BDA.
dated 11/3/24 is produced, wherein it is stated, after supplying reasons, that the request for refund of the additional title value, SITL, in the mentioned in the representation dated 1/12/18 was rejected. In that view, the order is complied with. Nothing survives in the contempt proceedings. Petition is disposed of. If the petitioner grievance about the merits of the order of enforcement as above, it will be open for the petitioner to institute independent proceedings to challenge the same in accordance with law. in respect of which this court does not express anything on merits.
Seal number 7, Mr.
Great.
Sharath Gowda.
Even in this, my lords,
Yes,
compliance
sir.
affidavit is not served.
Say endorsement issued, my lord, in case of Podi and Kata. There is litigations between the parties, my lord, that aspect, endorsement is issued, complaint.
My lords, I appear for the complainant, my lord, serial number 7. The order of which disobedience is alleged, my lords, is at page 70. The writ petition was filed, my lords, seeking for effecting Podi and Durust in respect of the petition scheduled property. In similar cases, my lords, they had reported, they had affected Podi and Durust and reported to the court. On similar lines, my lords, this petition was disposed of, instructing the officials to accomplish the task in question in petitioner's case. Herein, as has been done in the accompanying cases, the factual matrix being substantially similar in both sides, this is upheld. Therefore, a positive direction is given to affect Podi and Durust. Till now, they have not affected Podi and Durust. Till now, they have not affected Podi and Durust.
Because there are a lot of disputes are there, my lord. In between the party, even complainant also involved in that disputes. Accordingly stated that.
Let
the
them serve me
endorsement issued
the
cannot
affidavit,
hold.
compliance affidavit, notes, I will file by
File.
count.
The 26th of,
Yes.
in order to enable learned additional government advocate. To file compliance affidavit, stand out to 26th of November.
This is seal number 8, Mr. Naveen Jayan. Seal number 8, Mr. Naveen Jayan.
Podi is complaint.
19th.
Seal number 9, Mr. Manjunath G.
I appear for petitioner in this case, Your Honor. The respondents have complied with the notice given by this honorable court, so I respectfully submit to dispose this case, ma'am.
So and so appear for the complaint and states that the respondents have complied with the order brought under contempt. Learned additional government advocate, Mr. So and so confirms the compliance. In that view, nothing surviving is present contempt proceedings, the petition is disposed of as not surviving.
Seal number 10, Mr. Prasant Chandra S.
This is also for Podi, my lord. It is a forest land, my lord.
Mr. Prasant
Notified
Chandra
forest
S.
land. It is not
19th, nobody is there.
Seal number 11, Mr. Balraj AC.
complaint. Entry is permitted. Is not, it is also notified forest lands, my lord. It cannot be done.
But they have not served any copies of the.
Not serving copy to the, serve copy,
Totally forest land, my lord, not.
serve copy of the
I'll
order.
serve it and have it and some other day.
Otherwise, it will not be disposed of unless you serve the copy.
I'll serve it now. Thereafter, I'll serve it.
Whenever in course of the day, 19th at 2:30. 19th.
Seal number 12, Mr. K. Sridhar.
Again, in this case, copy not given. There was an endorsement that I have not seen in their file also.
Is complied, I think, my lord.
Representation is decided.
It is complied, my lord.
Where is it?
Submit
In serial number 12.
Endorsed by issuing endorsement.
28/8/24.
That is, it is not.
28/8/94.
They have not given me anything.
Now give.
I will submit, my lord. We have already sent to mail also, we have copies to the.
They have to give me.
I told come, my learned pen to give, we give the copy now. We have verified it. My learned pen has verified the affidavit.
He shown file.
We will.
In that
anyhow,
file
we will
also,
serve
there
the
was no
copy.
such endorsement.
Copy.
We will serve it, my lord.
Serve the
Have it on
copy.
19, my lord.
You ensure that a copy is given in all. We are keeping on, the rest of them are on 20th at 2:30.
Serial number 12.
Second list. In the meantime, you supply copy wherever
Please,
you don't
please.
serve, so that we may not waste the time.
13,
He will serve it now itself.
All
For
on.
the petitioner, please, my lord. Copy has
Hold on.
not been served, please.
See, Not so. So all matter may be kept in 2:30 in second.
In all matters, we have.
Apologies, my lord, I thought it was.
Doesn't matter. So in the meantime, you manage to supply copy.
Please.
All are on 20th in second list.
List to move it.
Rest are on 20th. Second list. Yeah.
List number 1. So 230 matters, seal number 91 for withdrawal of contempt.
For the complaint is matter, permitted to withdraw
Learned advocate. Mr.
by reserving liberty to challenge the endorsement, my lord.
Present contempt petition in view of the memo dated memo in view of the compliance affidavit filed by the other side in view of memo dated
Memo,
10/24 dismissed as withdrawn.
Reserving liberty to challenge the endorsement, my lord. Reserving liberty to challenge the endorsement.
Petitioner is not precluded from challenging the endorsement in question
91
merits if aggrieved by it by instituting independent proceedings. However, in respect thereof, this court does not express any opinion.
Seal number 92 to TP Vivekananda.
For the accused, my lord, I'm filing an.
This is the order dated 29/10/2000.
We have filed a review petition in this matter before the single judgment. It has been heard, my lord, it has been adjourned for the next week, my lord. Sorry, my lord.
Kindly see the order dated 29/10/2024, Lordships.
The directions are about what? Payment of back wages?
The portion of the residential side, my lord, has been utilized for the purpose of formation of road. Even after 2 years, my lord, the compensation is not determined and paid as directed by the learned single judge.
We'll call personal.
Lord, he's present before the court.
We send, let him go to jail straight away. We'll direct him to, who is the competent police officer? Let him go to jail straight away. We are not tolerating this kind of lethargy.
Yes, for
We straight away hold guilty of contempt.
review petition.
Or you comply with by 19th. Choice is yours.
Lord, the review petition.
Assess the compensation and bring the draft or check.
Sorry, my lord, we will.
Then you go to jail straight away, right now, with these very cloths. Who is the jurisdictional police officer here? He'll be taken into custody
Sorry, my
right
lord.
now. We are not tolerating this kind of lethargy.
Request, my lord, first week of December, 27/11 is the date
No.
before
No,
the
sir.
single
You-
judgment.
You determine the compensation and bring the check. Otherwise, you go straight away to the jail. Choice is yours. We are not dependent upon your lethargy and the adjournment in the other court.
Yes, sir.
Since how long this is going on?
This is going on from a very long.
So now decide. Only 2 options left.
Lord, if it is compensation, my lord, the officer in charge, my lord, will not be able
To
to take.
determine whatever compensation determine, bring the demand draft.
Yes, my lord.
What is the name of the, he'll really go to the jail straight away from here. On the same, with same clothes. We'll call the police officer and ask him to detain, holding that he is guilty of contempt on the face of it. So when you are going to comply with, tell us.
1st of December, my lord, 27.
No, 1st of December.
I'm sorry, my lord, 27/11 is the next day for review petition.
We are not
Dismiss,
going
my lord,
to-
I will
We
instruct.
are not bound by the dates of the other proceedings.
I'm sorry, my lord.
We are a contempt court. We are here to implement the orders. Do whatever you do internally, assess the compensation within 4 days and come here.
Lord, Joint Commissioner is also present before, he says 10 to 20 days, my lord, he will.
No, he can't put the court to terms.
Sorry, my
We are
lord.
putting you to terms. Come within 3 days. When you are going to come?
3 days, my lord. If my lords give us that opportunity, my lord, we will make, I'll try that.
Any resistance will lead them to jail only.
I will.
This is too much, Mr. Counsel.
Yes.
How long we are tolerating?
Sorry, my lords, but Trying our best to get
So
this.
tell us when you are going to bring the check for pass the order, determine compensation, compliance of the order and bring the check. It is for compensation or not?
Please,
Determine
not it is for-
compensation payable to the petitioner under the right to. What is this? Possession is taken when?
My lord, position.
In 2017 minutes.
Yes, my lord. Very sorry, my lords, but
No, sorry. We are not against anybody. We are only for implementing the order.
my lord, a week's time, my lord, I will make sure, my lord. A
How
week's time, my lord.
Week's time will give.
Full time, my lord.
As a last chance. From a time up to, today is what? Time up to
It's 15. I request for 25th, my lord.
27th of November is given. On that day, allotment. On that day, learned advocate for
Accused, my lord.
respondent. On that day, just
So-
hand over to 27th as a last chance. Full stop, learned advocate for the respondent, responder one.
Yes,
Assures. In presence of, who is present?
the joint
Assistant Executive Engineer.
Assistant Executive Engineer, my lord.
We are not concerned with designation. This is
Joint
contempt proceedings.
Joint Commissioner is also present.
We are not concerned designation. You took out the name and gave the to the court.
Yes, I'm sorry, my lord.
They are not supposed to tell the court.
I'm sorry, my lord.
They have no right to audience.
I'm
Please
sorry.
ask them not to to directly communicate to the court.
I'm sorry, my lord.
Take your name and designation and give to the court.
Yes,
We are not here to listen to your officers and party in persons. Yes,
yes. I'm
get
sorry.
the name right now.
Yes,
We are in the process of passing the order. So and so, holding the post of so and so, as well as so and so, holding the post of so and so. That the order dated, order brought under contempt shall be complied with, and the compensation payable to the petitioner under the right to fair compensation and transparency in Land Acquisition Act 2013 for utilizing the land to the extent of 1244 square meters.
Square feet.
Number 17, taking into account the present market value and the market value of the land shall be determined, and check/demand draft shall be brought, and that the amount shall be kept ready to follow the further orders which may be passed. So keep ready the amount.
yes.
And we'll pass the order on that day, what to do. Yes.
Please.
Much obliged.
Obliged.
That's number 93. So PIL, the CM Venkat Reddy.
Regarding
Serial
reservation
number?
of government lands in the Bengaluru from the land grabbers, my lords.
96, 93. What is it?
Reservation of government lands
Hmm.
from land grabbers, my lords, and seeking mandamus to government to take custody of the entire government land from the land grabbers. Last occasion, my lords, they have filed status report.
Who will appear?
On the last date, Neelapur Akbar, madam appeared, and I am the impleading applicant 10 to 15, my lord.
Pardon?
I am the impleading applicant 10 to 15. I got impleaded because these lands are all granted to the downtrodden persons in the year 1979. My impleading application is
Who will appear? You are appearing?
Statement of objection, the government has filed, my lord, and the last date of hearing, my lord, has
Number
taken-
5, who is number 5?
taken note of para 11 of their statement, my lord.
There is a reply filed by number 5. Who is number 5?
Number 5, my lord, the first date,
Number 5 must be some authority.
Tahsildar, concerned Tahsildar, Bangalore South Taluk,
Tehsildar.
Tahsildar.
So these lands is allotted now, allotted.
It's part of the land has been allotted to the downtrodden people in the year 1979. And
Lord,
para 11 of the statement filed by the learned government advocate on the last date of hearing, my lord has taken it note.
Who appears for number 5? You are ready?
No, my
Not
lord.
ready. So when you will be, your file reply, you just go through. It appears that the land is already allotted,
It is allotted.
plotting out.
We are all cultivating the land. We are in possession of the land. Certain allegations has been made.
You have filed some reply.
My lord,
You have filed some reply.
my lord, grant certificate I placed, the reply, I can put it on record, my lord. All grants,
Your reply.
reply not it.
You want to file?
I will file it, my lord. I will file it.
File it.
A specific date may be given because
You are already impleaded.
I am impleaded me in the,
The newly impleaded party shall file reply. Full stop. It will be also open to file further reply by the respondent authorities, including respondent 5, if so considered.
one date, because this is 2018 matter. Now port, everything has been completed. Because of this restriction, the revenue authorities are keeping in abeyance. A specific date may be given so that I can.
27th.
Please, my lord. My lord.
27 of this month, my lord.
27 of this month.
Nothing remains, Mr. Counsel. Only to confirm the statement made by the Sildar, we want their reply, so that both are outside. Otherwise, the land is allotted out.
My lords, may I read the status? Subsequent developments, they have not been submitted. It is for the government to submit.
You can also file whatever you want before next.
Please. 27. Problem.
Okay, sir, they have not been served, that's the reason. But serial number 59 had been passed over.
Pardon?
Serial number 59 had been passed over.
59 is passed.
59.
What
It's
is
a
it?
case where I'm appearing
59 is passed.
I'm appearing for the complainant mother in this matter, my lord. It's a case where I have been denied access to my child for 4 years now on the ground that the father has remarried and the child is getting accustomed to his new environment. The marriage between the parties was dissolved in December 2020, my lords, on certain terms and conditions. With the leave of the court, if I may go through the terms and conditions, my lord.
This is for office objection.
Lord, a reply was filed by the accused. There were some office objections to be complied on that.
Let it be notified on 25th.
In the meanwhile, if I may request for a video call, on the 6th of June, this honorable court had passed an order permitting a video
25th
call.
will consider. This is an office objection. We can't pass any order. So we are changing some system about this council submission office objection. You will have the right
Very
to
well.
argue
well.
itself. Yes, but after it will take 15 days also. Yes, next. Anybody?
Serial
the
number
leave of-
52, my lord, is a senior citizen, is an ex-serviceman, my lord. The grant has been made for effect of only 4 acres, my lord, but no documents has been given in his favor, my lord. And even in so far as the other 6 acres, they have not granted still, my lord. They have not complied with the order. He is running from court to court, from pillar to post, from past many years, my lord. So many rounds of litigation.
So list it on 26th. 26th.
26 of those.
With lordship's kind
admission.
With the lordship's kind permission, we are bold enough to place this memo on record. What has happened, this matter is very important prime government land, my lord. There was a review petition that was filed before this court, and the matter was heard by my lord's predecessors. Then what has happened is, my lord, the difficulty is that the bench has to be constituted and the matter for withdrawal has not been come. Now what has happened is the state has moved a SLP before the Supreme Court, and also a contempt is pending. We have given an undertaking that we have filed the SLP, my lord. The SLP was listed yesterday. The preliminary objection there in the SLP was that the review is still pending, my lord. Now the matter is relisted on the 22nd, that is next Friday before the Supreme Court, my lords. Now, my lord, there is an urgency that the review has to be withdrawn because the GO has been issued and a memo was filed before this court. In fact, a memo will also be presented before the RJ this morning. Previously also it was moved.
Review, you want to withdraw the review?
Yes, my lord. Then the problem is the bench has to be constituted, my lord. Special bench.
When the Supreme Court.
22nd Friday, my lord. That is the urgency. We have to file.
This 20, no, next 10.
Next Friday. Today is the Friday, next Friday. Yesterday matter was listed, my lord. We were before the court.
You want to withdraw the.
Yes, my lord. We want to withdraw the RP, my lord.
Tell the RG judicial to come with this detail.
It may be called on Tuesday, my lord. Tuesday.
It is immediately done.
Yes.
Lord, one other submission. Sorry.
So whose order is there? But who is the other? Other honorable?
Justice Kamal, my lord. MGS Kamal. A video conference has to be.